business with the appellate division draw near, give your attendance, and you shall be heard. Please be seated.
Good afternoon. There is more than 7 hours of argument time requested, so please ask for the time that you need, not the time that you wish. We've read all the briefs and records. We're familiar with the arguments, and if we have questions, we will keep asking them. People versus Frasier, appellant. Respondent? 4, 1, and 4. Barrett versus Sax and Sax, appellant.
Appellate 4 and 1.
Respondent?
Respondent 3, please.
4, 1, and 3. A. Kari, I am disqualified on that. I'm sorry, I should have asked you what the time was. No, you could tell me. Oh, great.
Appellant. Respondent. All right. 6, 2, 5, 6 and 5.
Thomas versus Esplanade, I could have taken that next time. Thomas versus Esplanade Gardens, appellant.
5 and 2, please.
Respondent?
Respondent 5.
5, 2, and 5. Zach versus Bronx Park, appellant.
5 and 2, please.
Bronx. Okay, Bronx is not here? Oh, okay. And how much time are you requesting? 3. 5, 2, and 3. Has the court been notified it was settled as to Bronx? You were going to notify me? Because that will affect the decision, I assume. It won't affect it, okay? You'll explain that. Manor Haven Capital versus Byrne, appellant.
5 and 2, Your Honor.
Respondent?
Respondent 5 minutes, Your Honor.
5, 2, and 5, and they'll both be argued together. People versus Messiah Wall, appellant.
5 and 2, Your Honor.
Respondent? 5, 1, and 5. People versus Khalid Diomande, appellant.
Appellant 8 and 2, Your Honor.
Respondent?
Respondent 8.
7, 1, and 7. Caitlyn Insurance versus Colony Insurance, appellant. Respondent?
3.
6, 1, and 3. 558 7th Avenue versus E&B Barbers, is the appellant here?
Yes, 4.
I'll give you 3 minutes.
That's fine.
People versus Frederick Burke, appellant. That is submitted. West 18th Street versus Allen, appellant.
5 and 2.
Respondent?
5 and 3.
Did you have a cross appeal? Did you have a cross appeal? Did you have a cross appeal? So, yeah, so you don't get rebuttal time. 5, 2, and 5. People versus Shamar Ross, appellant. Respondent? 7, 1, and 7. Jones versus City of New York, appellant. It is submitted. People versus Hines, appellant. Respondent? 5, 1, and 4. Knight versus City of New York is submitted, and Cardillo versus Archdiocese is submitted. So our first case for argument is People versus Frasier.
May it please the court, Svetlana Kornfein for appellant Jimmy Frasier. There was a reasonable view of the evidence, viewed in the light most favorable to the defendant, Mr. Frasier, that he committed petty larceny and not robbery. The court erred in denying counsel's request for a charge down
So what
to petty
argument,
larceny.
the only difference between the two is whether theft was forcible. based on the victim's unrebutted testimony, what argument could you possibly make that this was not a forcible taking?
Okay, well, the complainant's testimony was about the force was ambiguous. He describes this confrontation. He testifies that Mr. Frasier punched him in the face 4 times, in his mouth, cheek. His gums were bleeding. He had this serious pain, and that he was strangled, choked. He felt like there was a rope around his neck. He was temporarily blinded. And then at some point, he notices that the chain is gone. And then subsequently, he testifies that after Mr. Frasier left the train, he went down on hands and knees, looking under the seats of the subway car, looking for his chain, and someone said to him, "Don't bother, it's already, he took it already." So that, again, viewing the evidence in the light most favorable to Mr. Frasier, it's a reasonable juror could find that Mr. Frasier picked up the chain from the floor in that confrontation. The chain
Without any
could have
force?
fallen down. Yes, without, in the course of that happening. Yes, a juror could also
Force in
find.
the incident, though, that seems undisputed. There's no, what version of the events did not involve force in the incident?
Well, it's not really undisputed. I mean,
They had a fight and it fell to the ground and he took it, that you'd think then it's pettit larceny?
well, but he would have the intent to take it by force, and that's not been established.
Counsel, the unrebutted testimony was that he punched the victim twice in the face, right? There's nothing to rebut that testimony. That testimony, no one else
Well,
said anything
except
else.
that the jury acquitted him of physical injury and
No, of the
of robbery too, with the element
robbery
of
too.
physical.
That's a different thing, right?
Well, no,
So, okay,
no,
but
but
there's
that element
but
was-
the testimony is unrebutted. We agree that the victim testimony testified that the guy punched him twice in the face, and then immediately said to him, "Give me my chain back," right? Is there anything that disputes those two pieces of evidence?
Well, he never saw Mr. Frasier with the chain. He never described a yanking of the chain off of. How did the chain get off his neck? And there's no yanking. There's no pulling.
The strangling, you
no-
don't think that the strangling, the two
strangling-
punches and the strangling at the neck?
Strangling is with your hands. I don't really know what he was saying. What I'm saying is.
Isn't it likely that if the defendant pulled the chain off, that the victim would experience that as strangling?
I don't know. I mean, this complainant exaggerated his injuries.
How
He
do you know that?
exaggerated the entire.
How do you know that he
incident was
exaggerated it?
exaggerated.
There's no, I mean, his testimony about his injuries were unrebutted, so what is the basis for your claim that he exaggerated?
Well, again, the jury, he claimed that Mr. Frasier displayed a knife. The jury acquitted Mr. Frasier of first-degree robbery, which includes displays a knife as an element. The jury acquitted Mr. Frasier of second-degree robbery, which includes physical injury. And the physical injury described by the
Did the victim
complainant.
actually testify that he strangled him or that it felt like strangling?
He felt he was blinded, right? He felt
Isn't
like
that
he
he
was
felt like
being
strangling?
strangled. Yes, but my point is, a juror
Isn't
could.
that the chain being removed?
Well, I don't know. It could be, a juror could find that, but a juror looking at the evidence in the view most favorable to Mr. Frasier could find that somewhere in some confrontation, the chain fell to the ground and Mr. Frasier opportunistically took it. Otherwise, why would the defendant be looking on the floor for
Thank you
his
very
chain?
much. You have time for rebuttal.
May it please the court, Stephen Levy for the respondent.
So what's your answer to the to the victim looking on the floor for the chain?
So I'll answer in two parts, Your Honor. Immediately prior to looking on the floor, there was a long exchange during which the complainant Mong had repeatedly demanded back the chain. And to answer your question as well about the feeling on his neck, he had experienced a feeling on the front and side where the chain had been pulled, and that was the strangling feeling that he described. He then immediately,
He doesn't
No
say that he
pause.
strangled him. He
He
doesn't say
experienced-
that he strangled him, which would make you think of him using
Correct.
his hands to strangle him.
That's exactly right. He says he experienced a very forceful tightness as if he was tied by a rope in his neck. It dissipates. He immediately demands the chain back. But then to get to the end of the exchange, following the repeated demands where he says, give me my chain back, I'm not getting off until you do it. He's threatened and punched again. Still, give me my chain back. Once the defendant is gone, he does look on the floor. The reason he did that, though, is because this chain is a very valuable family heirloom. He cares about it very deeply. And however slim a chance there was that the defendant, after snatching the chain, had either purposefully to stow it away or accidentally dropped it, say, during the battle over Mr. Mong's phone. Your honors are familiar with the record. After the chain was snatched, there was several physical confrontations after that, including over Mr. Mong's phone after he had tried to, well, he did take a picture of defendant at the scene. So just as an example, Your Honor, during that confrontation, if the chain had dropped, Mr. Mong wanted to make sure that it was not still on the train because he cared very deeply about it.
And counsel, there's also testimony in the record that the victim suffered a swollen jaw and was unable to eat solid foods because of the incident.
That's exactly right, Your Honor. And that testimony comes from the complainant's wife, who is a physician as well. So to the extent you need medical expertise to tell something like that, even though it's even plain to a layperson, you can't have somebody more qualified than that. If you want to look at other corroborating testimony, too, about the fact there had been a physical fight and force used against the complainant, the police, who, first of all, confirmed that immediately after the incident, the complainant went right to them to confirm the crime happened. The detective who interviewed him also said, you know, when I was talking with him, he was touching his mouth and lip. He looked very shaken up. He looked very concerned, like he had gone through a stressful incident. So there was corroboration even beyond the uncorroborated testimony of Mr. Mong.
Thank you.
Thank you, Your Honor.
Okay, well, just to set the record straight, there were no further physical confrontations after that, even though they were in the car riding from Manhattan to Brooklyn. His wife initially testified she couldn't even remember, but the incident, because it happened a year or so before, but she remembered he had some soreness or whatever. So he told the detective, he told the jury that the detective took photographs of the injury, but the detective didn't remember seeing any injury after reviewing her file, and there were no photographs of the injuries. So the jury rightfully acquitted him, not finding that whatever injury he had did not rise to the level of physical injury. And again, I would stress, in terms of the strangling, Justice Friedman, he says, he wringed my neck and I felt like I was strangled. I felt like I was tied by the rope in my neck. Yes, it was a very forceful tightness. I think that looking at the evidence in the view most favorable to Mr. Frasier, one could interpret that as Mr. Frasier strangling him and not yanking the chain off his neck.
Thank you.
Thanks.
Barrett versus Sax and Sax.
May I proceed?
Yes, you may.
Good morning, and may it please the court. My name is Dan Smith, and I represent the appellant, Maria Barrett. Supreme Court erred in granting the defendant's motion for summary judgment on the ground that the defect was trivial and that plaintiff failed to identify the cause of the fall. I'm going to address the cause of the fall issue first. On page 38 of the record is the defendant's undisputed statement of material facts that they attached to their summary judgment motion. And in the undisputed material facts, the defendants state that plaintiff testified that the area of the raised area of the sidewalk that caused her to fall was approximately 1.5 inches. And then later they summarize their testimony further to say it was approximately 2 inches. So putting aside the fact that the defendants in the underlying case didn't even argue for dismissal on the basis that plaintiff failed to identify the cause of the fall, their own submissions clearly show that she identified consistently that it was a raised portion of the sidewalk that caused her to fall. As to the trivial defect, again, the defendant's own submissions in support of the motion raise an issue of fact as to whether the defect was indeed trivial. First of all, as I previously stated, there's the plaintiff's testimony that it was approximately 1.5 to 2 inches. And in addition to that, the defendants included the email exchange from the super of the building adjacent to the sidewalk where the plaintiff fell, which in effect he emailed his property manager
What
stating,
evidence did defendant give to support the argument, the prima facie argument, that it was trivial?
well, none, Judge.
So
Truthfully,
that is your argument that we never should even get to what
we
you
should
did
never
or
get
did
to
not
the
do?
opposing papers because the photos, the Supreme Court relied just on the photos to say it was trivial. The photos were taken by the defendant, because this is a legal malpractice case, and they're from a very high vantage point. You can't see the dimensions of the defect, and case law is clear where the photos are inconclusive, and we cited to Trinidad, which states that where the photos are inconclusive,
When were those photos taken?
the photos were taken on May 4th of 2017, about a couple weeks after the accident. And so the photos, they are completely inconclusive as to the dimensions of the defect. So we never need to get to the sufficiency of the opposing papers, but briefly, we also included an affidavit from an engineer who admittedly he went to the site many years later because this is a legal malpractice case. It's necessary that an expert retained by the plaintiff in a legal malpractice case is only going to get there at a minimum 3 years after the accident. And the engineer relied on data that was consistent from the photographs. He used landmarks that were consistent, and he opined that it was at a minimum 5/8 of an inch. But all that to say, the defendants didn't proffer any evidence whatsoever that would suggest that the defect was trivial, and the Supreme Court erred in granting the motion. And if there's no more questions, I'll rest on the brief.
Thank you.
Good afternoon. Good afternoon. May it please the court, Christina Riker for respondents. I'd
How
like
did
to,
you satisfy your burden of making a prima facie case that the defect was trivial as a matter of law?
yes, Your Honor. We relied on the deposition testimony of the plaintiff herself, who testified that she could not identify where she fell or the cause.
I'm not asking about the identity of the accident. I'm asking about the trivial argument right now.
We also relied on the photographs. There were
So is the photographs your only basis for your argument that it's trivial as a matter of law?
yes, Your Honor.
And how can we decide just based on the photos that defect is trivial as a matter of law?
Judge Kotler felt comfortable in deciding that, based on the photographs and her opinion, that the photographs did not show defects. They were color photographs. There were 25 of them. They were very clear. In fact, plaintiff's own expert relied on them in his opinion as to the defect. And it's consistent with the case law that it showed no snare or trap, and that there was not a height differential or anything else that was compounding upon a small, even if there was a 5/8 inch gap, there was nothing else that could have caused or contributed to her fall.
Counsel, can we both agree that whether or not a defect is trivial is an intensely factual determination?
Yes,
Yes? And can we also agree that at a minimum, 1/2 inch raises administrative code problems, correct?
Well, the administrative code says
I'm
that.
just asking you whether we can agree that that is true. At a 1/2 inch, you have to repair, above after, right? And we have held, as have other courts, that that's some evidence that it's not trivial, right?
That's correct, but
So in this case, everyone agrees, the testimony, the unrebutted testimony is that it was the difference was at least 1/2 inch, more. The plaintiff testified more. Her expert testified 5/8 to an inch, right?
well, no, her expert did not inspect the location as it occurred.
But there is he made an estimate, right?
He's the only, she did not measure the defect. She testified it was half an
Understood, but
inch.
she's the only one who actually saw, oh, actually, that's not true. Then the guy next door, the next door's maintenance man testified that it was more than half an inch, right?
No, that's not correct, Your
What
Honor.
did he testify
He testified that there was in the vicinity of her fall, that there was a drop in the sidewalk, but it wasn't where she identified that she fell in her testimony.
Okay, let's assume that I don't agree with that. Let's assume, what did the maintenance person say the difference was?
He also did not measure it, and he wasn't sure, and counsel admitted during oral argument that this was not the location where the plaintiff fell.
Right, the exact location.
Right,
But it was the same sidewalk flag, correct?
Well, it was a few feet from her location of her fall. She
Right.
fell in the corner of two flags, and the area that he identified was further down where there was a drop in the sidewalk, but not where she fell.
Okay.
Okay, thank you.
Thank you.
Briefly, in the defendant's moving papers, their affirmation in support, at record page 21, the defendants submit the photos taken by the superintendent of the building and specifically state they are photos of the defect. Their only argument in the court below was that Mr. Toderick didn't measure it. And just to be clear, Mr. Toderick is actually the super of the adjacent building where she fell. It's not next door.
What do you mean by that?
Well, it's a legal malpractice case. So
No, when you say, what is the significance of it being the adjacent building as opposed to the building next door?
the significance is he was the super of the entity that the defendants should have sued. We
okay.
obtained
I
that through
see.
non-party discovery. So in fact, he was the super of 245, which was owned by ASN Murray Hill, which the defendants failed to sue because they named the wrong entities in the malpractice case. So
Thank you.
thank you very much.
Thank you. I just want to note for the record, Bison Capital versus Hunton and Williams was adjourned. It's not your case, but I didn't state that at the calendar. The next case is R. Akari, and I am recused on that matter.
Your Honor, I'm sorry, I missed what the court granted for.
Just give me a moment. Thank you. Yes.
I'm sorry, Judge, I missed at the call what Your Honor granted for reply for appellant.
2.
Thank you.
Okay. Give me one moment. You may begin.
May it please the court, David Chalakline of the Family Justice Law Center for the non-respondent mother. This case involves an unbounded surveillance order over a family where the mother is an indisputably fit parent not accused of anything, and where the respondent father has been judicially barred from the home. This order was illegal on both statutory and constitutional grounds. As the briefs of the multiple and varied amici demonstrate, the issue is of enormous importance to families and children, and survivors of domestic violence are harmed in particular and pernicious ways by these illegal orders which compound the trauma inflicted by their abusers. On statutory grounds, as the Second Department recently held,
Counsel, I don't disagree with you about the importance of this issue, but as I understand it, the family court granted the mother's motion citing the ACS's offer to stop supervising the mother's home and its consent to vacate the order of supervision. So what are you asking us to reverse?
two things, Your Honor. One is the initial order from the family court that granted the ACS supervision, which was issued months before the motion to vacate. The second order, which the family court found that the motion to vacate was moot based on the government's, after months of litigating the motion.
So you want us to overrule the mootness determination? Because the other family court order doesn't stand in view of the, believe that was an order of a referee, which...
It was an order of a family court. It was a different family court judge.
Right, but it seems to me that the later order, the October 9th, 2024 order, vitiated the original order.
That's correct.
Okay, so we don't really, I'm not sure why we need to overrule that, since I think the family court already did that. So what you're asking us to do really is to reverse the order of mootness.
That's correct. The second order from the family court finding that the motion was
Okay.
moot because the government had switched its position.
Just a question. Do we know why the government switched its position? Did they say why they wanted to resolve this through a stipulation?
So, not in any particularized way. The government opposed the motion for months, filing motions in opposition, blowing past deadlines, asking for extensions, participating in oral arguments. And then when the motion after had been finally briefed and it was clear that the family court was going to rule against it, it offered to stipulate to vacate the motion. And that was not accepted by the mother because it did not offer her the full relief, particularly because the reason that ACS said, at least ostensibly the reason ACS said that they were switching was because upon further review of the case.
You're really looking for an affirmance, but on other grounds.
Excuse me, Judge?
You're really looking for an affirmance, but on other grounds.
That's true in a sense. I mean, the family court erred both as a matter of law and as a matter of fact.
You want us to affirm and adopt the reasons that you presented below for the relief that you sought.
That's
as
true.
opposed to the
Right.
reason that we should have, that the court used, which was that it was moot.
That's true, Your Honor. Yes.
Right, you got the relief you sought, but not on the ground that you would like us to address.
I would say mostly, but not totally, Your Honor. And
What didn't you get?
So during the course of months of litigating, ACS continued to press that they were
Got
entitled
it, but
legally.
that wasn't in the order that is on appeal. That has nothing to do with the order that's on appeal. The order that's on appeal gave you the relief you sought, which is to vacate the previous order having the mom be supervised.
Mostly only to the extent it didn't is that it didn't establish law of the case.
Okay, so again, I think what my colleague is saying is you want us to affirm the dismissal, but not on the ground of consent of the party.
Exactly, and I would point this court to this court's opinion in Puerto, which is the First Department case. Justice Friedman, you dissented from it, not finding that the exception to mootness applied, and Your Honor provided 3 reasons why, in that case, the exception should not apply.
So, counsel, am I correct that what you would want us to do is essentially follow the Second Department decision in matter of Sapphire?
That's correct. That's correct. And the reason is because now, talking about the mootness in the family's court, now we do need to find an exception to mootness. And all parties agree that it fits the exception to mootness, similar to in Puerto, where there was some accusations of the government obfuscating, trying to avoid judicial review. And that case is particularly instructive here, particularly, Justice Friedman, the 3 reasons why Your Honor did not agree that the mootness exception there was, 1, there was no evidence in the record that in that particular case, the government agency was trying to evade judicial review. The second reason was because there was no evidence in other cases the government agency wasn't trying to evade judicial review. And the third reason was because the government agency had conceded that the issue was illegal. On all 3 of those grounds, it cuts the other way in this case. The family court found that it was concerning what ACS did in terms of litigating the motion for months and then pivoting and switching its position for no particular reason. The family court said that it was aware that on numerous other occasions in other cases, ACS had taken the same litigative tactics. And here today, ACS continues to press that its ability to ask for these unbounded orders over parents who aren't accused with anything are legal. And they are doing
Let me just ask you, say we agree with you that this should not be an automatic thing. What remedies
we shouldn't agree.
What remedies would the family court have to ensure that the mom is keeping the child safe?
I mean, a number of ones. I mean, this argument that the state would become impotent to make sure.
That's what I'd like you to address, right? What does family court have?
So, I mean, an arsenal of powers and tools at their disposal, putting aside the illegal 1017 orders.
Wouldn't they have to start with having some reason to think that the mother Puts the child at risk?
Absolutely. I mean, that is the threshold determination that the executive branch has to make over a parent who's presumed to be fit. If they want some type of supervisory, surveillance, intervention into a fit parent's life, the very first determination they have to make is they have to accuse them with a cause of action. And that, of course, triggers a number of important due process and statutory grounds where a parent can challenge an
They're not
accusation.
without tools if they come to that conclusion.
Absolutely, they need some type of ground. But here they're putting the mother really in sort of this procedural purgatory where she has no means to get rid of it. But the statute never contemplated it in the first place, which is backed up by all of the constitutional issues that this order would raise and this court would have to reach if it did not hold that the statute didn't apply to mothers like her, families like her.
Thank you.
I'm sorry, can I ask one more question?
This is the last one.
Last question. Is the case that you want us to follow Puerto versus Dorr?
No,
which?
Sapphire VW.
No, I understand, but you cited one of our cases, and I didn't catch the
Yeah,
name.
Puerto v. Dorr. It's a
got
First
it.
Department case from, I believe, about a decade ago
Got
by
it.
former presiding Justice Acosta. Thank you.
May it please the court, the Legal Aid Society by Zoe Allen, appearing for the child. Just to address some of the questions that just came up. As to whether or not we would be supporting an affirmance on different grounds, I think there is actually a subtle difference because while the family court judge did indeed grant the relief of vacating the underlying order, she also sua sponte included other language in the order in which she was doing so, the second order which superseded the first order. First of all, she issued an order that had the same problem as the underlying order that issued at intake, in that it purported to release my client as if my client had been removed and the court was in a position to release my client to his mother.
And counsel, here the child was not removed from the respondent's home. It was the father who was the subject of a stay-away order.
That is correct. Never removed in his entire life. And by the time this case came in, and what we see from the record in this case, my client's father didn't live in the home.
I just have to ask you to clarify that. You're saying the last order that the court issued contained language about releasing the child?
Yes, and it also, what I found especially troubling, first of all, the release language is a reference presumably to 1017, which means that supervision presumably could resume at any time. There's also language that provides a roadmap for ACS to resume supervision if they want to do so, a procedural roadmap. In that regard, I think the order was error and is fundamentally flawed, even though part of it did, in the end.
But am I correct that you don't disagree with the result, with what was actually? I understand there are problems. I understand the problems you're having with the reasoning and some of the language. But in terms of the actual result of that order, is there any part of it that you're unhappy with?
Yes.
What is that?
It exposed my client to the risk of this extremely anxiety-producing
But
supervision.
what part of the order did that?
The part that said release and the part that told ACS how it could reinstate supervision at any time.
Okay, but that wasn't included in a decretal, was it?
I believe it was.
Okay.
So that's really the issue, is that in granting the relief, the family court still left the door open for this to resume at any time. And in the meantime, 10 months had gone by, 10 months of home visits that were weekly at times, every other week at other times, announced, unannounced.
I thought it was 15 months, no? Was it 15 or?
Well, so the original case, the incident that led to the case was in late December of 2023. This case was filed in the very first days of 2024, after a quick investigation, and I believe a criminal companion case. And by the time that the appellant got counsel, she was not assigned counsel initially. The court tried to find an attorney, but none was available. That happens sometimes. By the time she found counsel and her counsel got up to speed and filed a motion, she'd already had the supervision going on for 6 months. And then while the motion was litigated before ACS began its series of capitulations, that supervision continued. And based on the reports that are in the record, the supervision was pretty intense. And the reports themselves, they barely mention the respondent father. They basically say that ACS had very little contact with him at all. But the scrutiny on the non-respondent mother of my client is just very, very obvious.
And the child as well. The child was also
child, but-
searched as well?
Well, to the extent that services were needed, a fit parent can't be ordered to accept services, and a fit, protective parent who's parenting appropriately can make decisions about what kinds of things would benefit her child. Now, in this case, this parent was very cooperative. She didn't need to be, but she was very cooperative. But ACS came in with these reports detailing how cooperative she was and how compliant she was. And it doesn't seem like there were any repercussions for the respondent. But for her and for my client, there was this constant judging presence in the home. And
Oh, wait,
Repercussions for, I'm sorry, go ahead.
I was just going to say there was an order requiring supervised visitation, right? There were, the father, there was orders of protection issued. I think it's a little much to say nothing. The respondent got, nothing happened to the respondent, only all of
I
it to the mom.
apologize. I should have limited that statement. I meant in terms of casework efforts.
Continuing.
Casework efforts.
Right, continuing observations okay.
Just that people were not coming into his home, people were not tracking where he was, people weren't asking him.
Although
to
the
change
child wasn't in his home, right? So I guess.
No,
I
the
guess
child
that's
was in
probably one of the
same
reasons
home
why
of
no
the
one was
non-offending
tracking his
parent.
home.
Thank you, counsel. Thank you. Give me a moment.
Sure, Your Honor.
You can begin.
Thank you, Your Honor. Good afternoon, Your Honors, and may it please the Court. I'm Alan Racinas, representing the respondent ACS. Your Honors, this case is not about surveillance with its connotation of constant monitoring. This case,
Well, I have a question for you.
Yes, Your Honor.
So what were the concerns since the father was not in the home? There was an order of protection. So what, if any, safety concerns were raised?
I think the concern in a nutshell, Your Honor, is that the respondent father would not necessarily comply with an order of protection. I mean, this is a father.
Let me stop you right there.
Yes, Your Honor.
Was there any issue that the mother would not, cooperate or comply with the order of protection?
No, Your
Where
Honor.
does that come from?
Your Honor, I think the ACS's main concern is that to some degree it's out of her control. You have a potentially violent father, an allegedly violent father.
Well, is there any
how would
particularized concern about her not seeing that this order of protection is upheld? Because otherwise, every time there's an order of protection, that would automatically mean that the mother against whom there have been no charges comes under supervision. I mean, you're just taking, well, there's an order of protection, maybe it's not going to be observed. Do you have any reason to think it's not going to be observed?
I mean,
on her part.
Yeah, Your Honor. So I would just respectfully quibble with the premise that this would mean it would always apply because of the severity of the alleged facts in this case in the verified petition. I mean, this father stomped the mother to the point where she was unconscious.
Wait, but how would having a social worker come to her home and examine the child's body and examine the contents of the mother's refrigerator contribute to protecting the mother from this very violent man?
Well,
It seems to me that your remedy has nothing to do with what you claim you're concerned about.
there are instances where the respondent father has been found hiding in the home, that's a possibility.
What's that got to, but that has nothing to do with, for example, the fact that your workers examined the child's body and looked into the mother's refrigerator invasively. Why, how is that in any way related to the concern you claim?
I mean, the refrigerator we can debate that, but I think that that it doesn't relate directly to domestic violence. I agree with you, that premise. But I think that examining the child's body, by the way, the child was like 1 or 2 years old here. It was not an invasive search of a 7 or a 13-year-old. And that's to make sure the child hasn't been harmed. I mean, if the father...
Don't you need some reason to think that the mother's not going to abide by this order of protection?
I don't think so, Your Honor, because in the sense that the father, if he forces entry into the home, the mother can't stop him. I mean,
I'm hearing all these ifs. What I like to know is, what, if anything, did the mother do or not do that warranted such intrusive action?
Well, let me answer it this way, Your Honor.
No. Please answer it the way I'm asking. So I don't want an if. I'd like to know what the mother did or did not do that warranted, such intrusive actions by ACS.
I mean, I would quibble with the idea that it was intrusive, Your Honor, but I think that the
Searching the child, that's not intrusive?
Your Honor,
No. That's not intrusive?
to ensure that the child is not harmed.
What, if anything, did the mother do or not do to raise that concern?
Again, Your Honor, I think that if you don't buy this answer, that's fine, but the answer, I think, is that there is a concern that the mother does not have complete control of the situation.
Well, give me another answer, 'cause you've been repeating that.
Well, if that answer doesn't satisfy you, I'm not sure if I can answer the question, but let me answer the way I want to answer it too, which is there's a bigger question here, which is whether the statute itself authorizes.
Where does
Not
the
just in this
statute
case.
authorize that as to a non-respondent parent from whom the child has not been removed? I don't see anything in Family Court Act 1017 that authorizes that. So I'm glad you got moved to the statutory argument, because I don't see it.
Yes.
And the family court is bound by the statutes that that govern it, and I don't see anything in the Family Court Act, Section 1017, to permit this behavior as to a non-respondent parent from whom the child has not been removed.
Right, and that's
And
because
where
it's not
the
in
respondent
1017
parent has always resided elsewhere.
It's not in 1017 alone, Your Honor. It's 1027D that authorizes an order under 1017-2A2 in this instance. And 1027D authorizes that in a number of, there are a number of hearings that 1027A refers to, one of which is 1027A3, which is expressly a hearing in a scenario in which the child has not been removed. So
But you didn't move under that statute. You moved under 1017. So why are you talking about a statute that you didn't move under?
I don't think we explicitly talked about either statute, Your Honor. But even I'm not aware of us saying 1017. But even if we did,
When you bring a
erroneously-
petition, what do you put in the petition? Just generalized statements, or do you cite a Family Court Act section under which you are moving?
I mean, I'm thinking more of what happened at the hearing, Your
No,
Honor.
I'm talking about your petition.
I don't
right?
remember, Your Honor. I wasn't.
I would be shocked if you didn't remember.
If I didn't remember,
Yeah, come on.
I
You know what you.
I am not aware
you
of that
can't
being in-
imagine that you think that you brought it under a section that you're not talking about in this appeal.
well, I mean,
And why are we all here talking about 10.7, that section of the Family Court Act, if you didn't bring the petition under that
the
section?
petition is a neglect petition, or a neglect petition. It's not about the. But the question here is, where is the authorization for the family court to release a parent, a child to a non-respondent parent in this context, a non-removal context? And the answer is 1027D, Your Honor.
So, counsel, this is going to be the last question for you.
Sure, Your Honor.
So why isn't the Second Department case of Sapphire W., why isn't that controlling here?
So they barely looked at the 1027D issue, Your Honor. They looked mainly at 1017. There is another argument that we made that the word removal in 1017 sub 1 include a situation where a removal technically did not occur. We're not making that argument here, and the court barely reached the 1027D issue, and insofar as it did, it said that 1027D did not provide an independent basis to issue this kind of order, and that's simply, respectfully, that's simply wrong under the law under the clear statutory language, Your Honor, of 1027A3 and 1027D.
All right, thank you.
Thank you, Your Honor.
Give me a moment. Thank you. And before we begin, let me just say that I gave each side 6 minutes, okay? So now you have 2.
Thank you, Your Honor. 4 points.
So I would, yeah, why don't you start with 1027D?
Sure. So two arguments on 1027D. One is that a 1027 hearing did not happen. And second, even if a 1027 hearing happened, it wouldn't apply. Starting with the first, 1027 hearings are major events in family court.
That's the next day you have to have the hearing.
Exactly.
and
There's
then- yes.
witnesses, there's testimony, there's cross-examination, there's prima facie motions, there's
That
summations.
really doesn't happen, that doesn't apply to this proceeding, because none of that happened, there was no allegations under that proceeding, right? Under, that we had to, that the court had to have a hearing the next day.
That's right.
So
and-
maybe in some other case that might have efficacy, but not this one.
but certainly not this case.
Okay.
Now, let's assume, just for the sake of argument, which, as we say in our brief, it clearly did not happen, but let's assume that there was a 1027 hearing. 3 arguments why 1027 does not somehow cut off the first half of 1017. The first is that 1027D, the provision that ACS relies on, explicitly states that it must be, quote, in accord with 1017A2A. In accord with means it obviously has to comply with the statute. When you look at 1017A2A, it talks of such non-respondent parents. Well, what non-respondent parents is the statute talking about? It's talking about the earlier provisions in 1017 that say after a child has been removed, ACS has to go out and locate a new caretaker, potentially a non-custodial parent. It has to investigate that parent. So it's clearly a reference back to that non-respondent parent. Second, ACS's theory of going from 1027 to 1017 is somehow that the whole provision of 1017 does not apply. I mean, it's hard to follow, but they say 1027D gets you to only part of 1017. But the problem with ACS's argument is that it then looks to the whole statute and only picks some provisions that apply and not others.
And also, isn't that the statute that the family court was relying on in imposing these, this supervision on the mother in any event?
That's absolutely right. And can I just say one thing?
30 seconds.
Thank you, Your Honor. I would just stress that as this panel's questions reveal, and as the many amicus briefs that are submitted, as the attorney for the child, the Legal Aid Society showed, as the Second Department's decision in Sapphire W, this is an issue of enormous importance that family courts call a central issue in the modern welfare state.
Thank
It
you.
is critical that, can I take 5 seconds?
I said 30. Thank you.
Thank you, Judge.
The next case is Thomas versus Esplanade Gardens, and Justice Kennedy is recused.
May it please the court, my name is Kenneth Amarello of the law firm of Smith, Buss & Jacobs on behalf of the appellants Adrian Thomas and Joseph Lawrence. The issue in this case is whether a board of directors of a cooperative can define public information in a lawsuit to be confidential information and then have that definition protected by the business
Sorry,
judgment
isn't
rule.
the issue isn't, I would phrase it differently, isn't the decision by the board in this case protected by the business judgment rule? It seems to me you have to start there.
That's the reverse way of saying it, but it's equally true, Your Honor, thank you, and it's appellant's position that public information can't be defined to be confidential information, and that therefore the removal of the appellants, which was based on defining information in a prior shareholder derivative action that was unsealed, where respondents participated and never requested that any information be sealed, which indicates that they didn't think it was
So
confidential.
what about the information specifically about divulging information that the New York City Department of Housing Preservation and Development directed Respondent's Management Company to commence an administrative proceeding regarding a board member's alleged residency? Why wouldn't that be a valid basis for removal?
Because, Your Honor, the predicate notices for the removal meeting that was held in May of '23 didn't say and didn't charge that you revealed confidential information in the prior shareholder derivative action. It said you revealed confidential information at subsequent town hall meetings, which were talking about whatever information was discussed at these 3 town hall meetings was information that was public knowledge by virtue of the prior shareholder derivative action. So the notices only said, you talked about things that are confidential at the town hall meetings.
When
They
did
weren't
the fact that
confidential.
HPD said that there should be an investigation of their residency status, when did that come out?
Well, Your Honor, in the prior shareholder derivative action, respondent put in an affirmation by the board member whose residency information was one of the issues of the shareholder derivative action. And respondent's board president put in a 20-page affirmation. They both discussed HPD's investigation, denied the charges that the board member was not residing primarily at the co-op, which is required by Mitchell-Lama rules and the co-op bylaws. And we cite in the brief the page numbers, and the actual documents are there. So both sides talked about this residency information, which was by public policy and statute the appellant's right to bring a shareholder derivative action. There's no question that that was a protected right. Yet subsequently, the argument was, and the motion court completely disregarded the fact that the information that supposedly was conveyed at these town hall meetings, no evidence of which was ever stated on the record. They never presented any statements that said, this is what you said, that was confidential information.
So I mean,
Motion
even,
court
okay,
ignored
but,
it.
so you, all I hear is like intense minutia. Lewandowski says, unless there is some real bad faith, or really, and you are disputing whether all the information that was given was confidential or not, even if some of it was confidential, how, I mean, we're not supposed to, courts are not supposed to get involved in shareholder disputes.
Your Honor,
Let me finish, please. Like this. This is precisely what Lewandowski is asking shareholders in co-op corporations to avoid, is this kind of he said, she said, and it was this little piece that was bad, even though that little piece was good. That is all wiped away. And we are not supposed to get involved in that. You have to show some real bad faith. And so what is it that you're showing here? You're saying, well, we don't agree with their view of what was confidential and what wasn't. I have not seen a single case where that was found to be bad faith sufficient to get a court involved in a shareholder dispute.
Your Honor, Lewandowski said that
I know what Lewandowski said. We all know what
But
Lewandowski said. We
Lewandowski
deal with
is-
Lewandowski a lot.
Lewandowski is not a rubber stamp, and the business judgment rule is not a rubber stamp for malicious or arbitrary decisions that don't take the facts into consideration here.
What evidence is there of malice or bad faith here?
Yes, Your Honor, we showed that the same similar trumped-up charges were brought by the same board majority in 2022 and then dropped, and they came up with another set of spurious charges. Plus, they never presented any evidence at the hearing. They never presented any witnesses. They ignored the 5 witnesses that were produced.
Thank you very much.
Thank you, Your Honor.
Good afternoon, Your Honors. William Geller on behalf of Respondent Esplanade Gardens. As several of Your Honors have identified, the issue here is not a platonic consideration of what's confidential. It's whether the board appropriately determined that the board member's responsibility to keep shareholder information confidential extends to information that might otherwise be in the public sphere. In this case, because those same board members brought a case to put it in the public sphere.
Well, and
this-
so at least at a minimum, the information about HPD telling you commence an investigation and commence a proceeding because there's enough information to show that this person, this was not her primary residence. That was not something that was publicly available, correct?
Well, before the filing of the prior action,
Right.
there was two confidential reports, one of which HPD
But isn't he
said-
saying that that became, they put that out in the prior action, the prior derivative action?
Right.
And I think his argument must be, well, that they had a right to do.
We don't dispute that the petitioners here had the right to bring the prior derivative action. That was, they're asserting their rights in court. The issue here is several days later to say, hey, we brought this proceeding and here's all the confidential information that we received as board members, and 90 to 200 shareholders in a meeting will talk about all of
I
this.
mean, they couldn't allege that in the lawsuit? They couldn't put that into that lawsuit?
They did allege it in the lawsuit. They said,
But you're saying that that brings up the breach of confidentiality, subjecting them to removal.
that they put it in the lawsuit is not the basis that they were removed. The basis by which they were removed is that several days later and then several months later, they had town hall meetings where they
called attention to what they had put into the
to
lawsuit.
it. And they said many other shareholders who might not have known it, they said some of them had done independent research to do it, but others didn't know anything about it until the
fact that they were allowed to disclose this in the lawsuit didn't mean they were then allowed to talk about it in other venues.
Precisely, Your Honor.
Thank you.
Thank you.
Your Honor, once the lawsuit in the prior shareholder derivative action made the information public with respondents' participation, it was to the extent it was ever confidential, this was only about where the board member lived. To the extent it was ever confidential, it lost that confidentiality. It can't be then, you can't put the toothpaste back in the tube. There's nothing in the record to show that the board established any statement that was said at any of these town meetings. So counsel is saying like they gave everything up that was said in the prior. There's nothing in the record on that. There's
Well,
nothing in the
what's wrong with the board adopting the view that, yeah, you put it into that other lawsuit, that's fine, but that doesn't mean that you're allowed to talk about this at a meeting of the board or at the meeting at a town hall meeting?
Your Honor, there's a public policy that the First Department has adopted that court records are available for review and access. Once they're reviewed unless there's under a seal order.
That doesn't mean, or does it, that you as a board member have a right to now talk about this publicly?
Yes, it does, because once it becomes in the public knowledge in an unsealed, publicly filed docket, which is under no seal or under any.
And that's really not even the question. The question is whether the board could say, we're not going to tolerate that.
But, Your Honor, that's an act, that's outside the board's authority. The bylaws don't give them the right to say, public information, we're going to consider it confidential information, even though there's a New York public policy that says it's open to the public and accessible to the public, and confidentiality is the exception, not the rule. If they had asked for a sealing order, this court would have had to, under this court's precedents cited in the brief, would have to deny it because confidentiality is the exception. There's no compelling interest here to protect a board member's residence, which permits her to sit on the board from being not disclosed.
Thank you.
Thank you.
The next case is Zach versus Bronx Park, and Justice Gesmer is recused on that matter.
Afternoon, Your Honors. May it please the court, Michael Zhu, appellate counsel of the Guerrero Rosengarten, attorneys for the plaintiff appellant. Before I start, I just want to say that the action against Bronx Park
I agree, it was settled, but it
settled.
doesn't change anything.
Does not
'cause
change
The
anything.
argument's still exactly the same.
Correct.
Once I looked at the papers again, you were right. It
Yeah.
makes absolutely no difference
And came as
to
a
the
great
resolution
surprise.
of the issue.
I learned of it after my reply brief was filed, but in any event.
It wouldn't change anything about it.
The lower court's order should be reversed because it erred in granting the defendant's motion to dismiss as untimely the second action. The first action, there's really should be no dispute about. The first action was dismissed on June 23rd, 2022, based on lack of capacity to sue.
Is the main issue whether or not you get the savings provision in this case? So what's your argument as to why you get the savings provision?
So under 205A, if
There
the action...
there's no neglect to prosecute in this case, right?
Correct. There is no neglect to prosecute because that prior action was not dismissed for want of prosecution. And in the second order, in this most recent order, there's no showing of a pattern of a failure to comply with any discovery orders. Because, well, first of all, in this second action, this was a pre-answer motion to dismiss, so there was no discovery in the second action. In the prior action, in the first action, the motion that was made by the plaintiff for a stay and seeking to substitute, in those motion papers, there was nothing in those papers where any defendant raised an issue as to want of prosecution. They didn't say, hey, no, you don't get to substitute because you failed to comply with 3-court orders. There was no evidence of that. So this second order, the judge can't even rely on anything that occurred in that first order as a basis for arriving at its
There was no reason for the
conclusion.
judge not to allow.
I'm
you know,
sorry?
There was no reason for the judge not to allow the plaintiff to have the benefit of the tolling provision.
Correct. Agreed.
That's your argument,
That's my argument.
because there's no neglect. Thank you.
Good afternoon, Your Honors. May it please the Court. Julia Audibert with Wilson Elser for EJ Electric. The plaintiff cannot take advantage of 205A in this case because the first order, I will note that the motion to substitute that was filed by the plaintiff in 2021 before the first order dismissing the case was only filed after the defendants filed a motion to compel discovery. So I just want to note that, and that there was a significant amount of failure to prosecute that was then laid out in that first order.
Has there ever been made a finding by anybody, any judge, that there was a failure to prosecute in this action? Was the dismissal of the first action have anything to do with failure to prosecute?
The first order lays out the dates in which the
Is
plaintiff...
there any finding by the court in the first action when it dismissed it that it was being dismissed because of any failure to prosecute?
All I can say is that in the first order, they lay out the pattern of neglect, which is the requirement, and then in the second order,
Doesn't
the
have to
same
be
judge...
some finding by a court that there actually has been a neglect to prosecute as the basis for the dismissal?
And this same judge that handled the first order and the second order in this case looks back at, revisits their first case.
Right, but does the judge make any finding whatsoever that the reason for the dismissal of the first action wasn't the reason for the dismissal, let me rephrase it, wasn't the reason for the dismissal of the first action lack of capacity to sue rather than neglect to prosecute? And isn't that an established basis for taking advantage of 205A?
The second order of the court does relay that it was based on, the dismissal was based on the neglect of the case. And it is interpreting in the first order the fact that in that first order they laid out the
Where does it say that in the second order?
second order states that plaintiff's delays over the past 3 years and 6 years.
That,
plaintiff's
you're
injuries are now
saying that
fatal.
that says I granted the first order based on delay? Of course
I'm saying
not.
that
The first order is I'm granting dismissal because the plaintiff passed away. You're not yet her administrator, and therefore there's no one with capacity to sue. You have to agree to that, correct?
after laying
That's
out
what
the
it
pattern
says,
of neglect,
right?
and then
But I can say whatever I want in dicta, right? And I appreciate that you would like that dicta, but that's not what the order was based on. It was based on lack of capacity to sue, correct?
that was the final state, the final.
Okay. Doesn't matter what the dicta is, doesn't matter how much I chat. The court below dismissed based on lack of capacity.
And the second order then
Is there
revisits
any
that original
dispute- is
order.
there
And again,
any
if there's
dispute, counsel, that if the dismissal is based on lack of capacity, a plaintiff gets to take advantage of 205A?
I'm sorry, can you say that again?
Is there any dispute under the law that if an action is dismissed for lack of capacity, and there's no dispute that was the ultimate reason for the dismissal, that a plaintiff gets to take advantage of 205A.
No, there's no dispute that that's the law.
Okay, thank you.
Thank you.
Just one final point, lest there be any issue as to whether the second action was commenced timely. The defendants argued below that the second action was not commenced within the 6-month time period because the date of the order was June 23rd.
It's your contention it goes from the date of entry.
Correct. And it was entered 6 days later, and so the commencement of the second action, it was within the 6-month of that June 29th
Thank you.
entry.
Thank you very much. Manor Haven Capital versus Byrne. Oh, sorry. And I started your time already.
Please, the court, Your Honor, Brian Isaac. I represent the defendant appellant in this case. When I was thinking about how to argue this case, I came up with this, and I think it works. There is a fundamental difference, or I should say, I hope it works. There's a fundamental difference between a contract that pays you a fee for contact and for something that's earned. And if you take a look at the first iteration of the agreement, which was the one that the plaintiff provided, that would have been a contact-based payment, right? The first clause said that there would be a tail fee for any offering undertaken by the Byrne firm with any lender or investor contacted by Manor Haven during the term of this agreement for a period of 18 months following the date of the expiration of this agreement. Shaw was absolutely contacted, and if that was the provision and there was a deal done within 18 months, my client owes the money. My client said, and you know this because the final iteration doesn't have this, it has the qualifications.
I'm sorry, could you speak up? I'm having a
I'm
little
sorry.
trouble hearing you.
Yeah. We don't want to do that. We don't want to give you fees for cold calls. We're happy to give you a fee after 4 months, even though it's a short 4-month agreement, but you have to earn the fee. And I think...
Wait, we have to look at the language of the contract.
Sure do.
So doesn't the language of the contract use exactly what you don't want it to use? That the tail provision applies to anybody contacted by plaintiff during the term of the agreement. Isn't that what the agreement says?
No, but
As long as they put in schedule,
right, so
schedule and listed.
I'm sorry, I didn't mean to interrupt. The language that they added is this. You will get the fee only for 12 months, provided that the plaintiff, quote, shall have kept the defendant apprised on a contemporaneous and continuing basis with the names, key contact information, and status of conversations with potential lenders for the transaction, which information shall be set forth in Schedule 1 as amended from time to time.
Is there any dispute that D.E. Shaw was contacted, that there were discussions, that D.E. Shaw said, I'm interested, but this amount is too big, so I'm going to decline to extend financing, but keep me in mind, and this all happened during the term of the agreement, and that the defendant was apprised of all of this?
But they
What
have
other
to do it-
information would there be?
I'm sorry, I didn't mean to cut. It has to be done on a continuing basis. Here's my argument.
What more? Once D.E. Shaw said, I'm interested, but the sum is too big, but keep me informed, but I'm declining to extend, what more was there to keep apprised?
Well-
Till the tail, where all of a sudden it was alone.
Because that's exactly what they contracted for. In other words, as I read the record, and if you look at Mr. Moran's deposition testimony and look at his affidavit, he says this deal is dead in November of 2021. Specifically said that they weren't even looking for anyone else. Let me read it to you. It's
There's
not.
no provision that requires that anyone potentially interested be contacted once a month or whatever. And I don't see, I'm having trouble understanding where you get the obligation to contact them again and again.
Well, Judge Gasper, I'm getting it from the language of the agreement itself.
Which language gives you that?
Specifically, this language, the language that the
Give me a
tail
page
will
like-
extend, provided that the Byrne firm is, quote, apprised on a contemporaneous and continuing basis with the names, key contact information, and status of conversations with potential lenders.
Isn't
That's
there
just
another issue, and this is favorable to your position, I'm trying to understand it. I look at Schedule 1 as it appears at page 845 of the record, and all it is a list of names. Now, clearly, Article 5 calls for more than just providing a list of names. How is there any indication, how did they comply with that requirement that you've been reading from, which says it's got to be on Schedule 1? It's the fact that you've exchanged emails or anything like that. That doesn't satisfy what this contractual provision states.
yes. They sent 2 emails with 2 schedules. One.
One second, let me add, or does it?
That's it. That's it.
Fair enough. There were 2 schedules that were sent. One, was September 22, 2021, after the defendant principal received that email from one of the people that were cold called saying, be careful, your information's going out. That was 49, that had 49 names on it. There's no information on it. It's just a list of what occurred. And then on January 4, this is after the agreement ended, you have another list with 56 names on it. There's nothing about who was contacted. There's nothing, I'm sorry, may I?
Just finish the question.
Yeah. There's nothing about what was done. There's nothing about the transactions. There's nothing about the status of the transactions at all. And I would also point out that if you look at the contract, it also says that the schedules have to be in writing and they have to be amended from time to time. Those are the only 2 schedules I see which do not comply with the literal terms of this agreement.
Thank you.
So let me start you off with this question, counsel. After you sent that
Wait,
schedule,
you didn't introduce yourself.
as I just said, I'm sorry, I want to get this out
may it
before I
please the-
forget it. I
May it
apologize.
please the court, Eric
Yes.
Fisher for plaintiff respondent, Manor Haven Capital.
After the Schedule I was sent, first of all, there was information, all of the information about this particular buyer, what was given to them, what they said, when it was sent. That was all forwarded. There's no question that that was forwarded to the plaintiff, correct?
Yes.
Yes. And when the plaintiff got that schedule, Schedule I, did the plaintiff ever say to you, this is not satisfactory, I need the information that you sent me in the separate email to be stapled, to said, did a plaintiff ever say anything like that?
No, Your Honor.
Was there any question from the plaintiff whether or not you had sent the information that was required, which is, here's who I contacted, here's what we gave them, they had access to the data room, they looked at the data, they went through the deal, they said they weren't interested. All of that was transmitted, plus their name on that schedule, correct?
That's all correct, Your Honor.
And the plaintiff never objected to any of that, correct?
Absolutely correct.
And more than that, Article 5 doesn't say that putting the names on the schedule is enough.
No, Your Honor, absolutely, of course. The language does say it should also include contact information. The schedule itself did not include contact information. Of course, there's no denying that.
And when's the last time you furnished this information in these emails?
So, Your Honor,
you're in the Article 3 timeframe, are you not?
We furnished we furnished the information on 2 occasions. First, we furnished a coverage list.
When did Article 3 come to an end? What's the date that Article 3 comes to an end?
Do you mean the contract period?
Yeah.
The contract period comes to an end at the end of December 2021, end of calendar year 2021.
So when after that date did you give information? No, that's under Article 5, but you're operating under Article 3, and it comes to an end, and then you have the fee tail that you have a right to get paid if something happens afterwards.
Yes, the contract term came to an end December 2021. The fee tail period ended 1 year later, December 2022.
So when's the last time you furnished any information to?
The last time was January 2022, shortly after expiration of the contract period. So we furnished information once during the
And what did you say in that information?
We said, there was a letter, and it said, we're sending this letter pursuant to the contract, attached to Schedule 1. It identifies those potential lenders we contacted. And
Just the names?
Yes.
Just the names, no other information, not key contact information, not status of conversations with potential lenders, none of the things that Article 5 calls for.
Well, okay.
If I may, I'm sorry, Your Honor.
No, go ahead, answer, please. I'm sorry, I didn't mean to interrupt.
Your Honor, You've referred to Schedule 1. It's at page 152 of the record. It only contains the names. It is a
No, the
fact.
trouble with that is, as a practical matter, actually, you give them 50 names, 30 names. We contacted with all of these people. What you did with them or didn't do with them, and then you can come along in this fee-tail period and say, oh, we put it on Schedule 1. We're entitled.
A few things, Your Honor. First of all, just to disabuse the court of that notion, that is not what happened here.
I'm not saying that it is, but what you're suggesting could happen, it would allow that to happen.
But that's not what happened.
You have to look at the individualized transaction, though, and decide in that particular transaction, right, whether or not you satisfied your obligations.
When we first presented the transaction to D.E. Shaw and had them sign an NDA and put together a data room and kept Mr. Byrne apprised of that on a regular basis, they decided that the transaction was not of a size that they
So that's what I want to ask you. There is no doubt that you did give the key person's name, the data room information, the result of your, all that information was given. It just wasn't stapled a second time to Schedule 1.
And Your Honor, they ended up doing the transaction through someone named Mr. Gallagher at D.E. Shaw. And Mr.
But how do you comply with the requirement that you apprise them on a contemporaneous and continuing basis with the names, key contact information, and status of conversations with potential lenders for the transaction?
So, Your Honor, I think it is very important, and this is what I think the court below recognized.
But you furnished was what relates to what happened in the past.
So this is very important. There was nothing to update. Once we were told by D.E. Shaw, we are passing on the transaction, and we communicated that to Mr. Byrne, that is where the transaction stood until after the expiration of the contract. As it turns out, some period later, during the fee-tail period, they changed their mind.
Thank you
and
very
they
much.
came back.
And they did the transaction. Thank you.
Thank you, Your Honor.
So, Your Honors, I'd like you, before you decide the case, to look at 906 of the record. Specifically, this is Mr. Moran's testimony, starting on line 5, going to line 14. I'm going to read it. Question: is it fair to say that by November 24, 2021, that you, being Manor Haven Capital, had stopped actively pursuing potential lenders on behalf of the Byrne firm? Answer: it appears so. We may have had some communication with lenders, but I don't believe so. It could be mistaken. I don't believe that the data room was made live again. We certainly didn't have lenders in the data room. Your Honors, that is 5 weeks before the agreement ends.
Counsel, why aren't we just looking, though, to be frank, at this particular lender and whether the condition was satisfied as to this particular lender, which goes back to the point that keeps getting discussed here. There was no question that this particular lender had said, no, I'm not going to pursue it. That was communicated to your client, and that was all that was required. It's the agreement. Whatever happens with any other lender, that is not the issue before the court. It's just whether it was activated to this particular lender.
So, Judge Kern, let me try to answer that question in a way that would make sense given everything that everyone's been arguing here, okay? That is functionally the same thing as what I refer to as a contact fee. The deal is dead. As I read this agreement, what the defendant was bargaining for was clearly a situation where the actions of the plaintiff actually caused this to occur.
It doesn't say that. No, where in the agreement does it say that?
Because that's...
Where? I mean, this is just like a real estate deal. If you go back after the exclusive ends and you do it with the same person, they still get the fee. There's no requirement, there's no procurement requirement, there's a contact requirement.
There's a contact requirement, an
That's
update...
different than a procurement requirement.
There's a contact requirement, there's an update requirement, it has to be in writing. This is what they contracted for. And I would point out one other thing. When you talk about what's in the record and what's not in the record, and I think Judge Scarpullo did that, if you look at what Mr. Burns said, Mr. Burns' testimony and Mr. Marin's testimony is completely different. 649 to 650.
No, we're going way beyond the questions that were asked, though, counsel. I mean, we're familiar with the record.
Okay, so I would just ask you to look at 649 to 650.
Thank you. People versus Wall.
Good afternoon, Danielle Bernstein from the Legal Aid Society on behalf of Mr. Messiah Wall. Before we turn to the suppression issue, Your Honors, I wanted to begin by addressing the sentencing issue because it's a very straightforward ask. A misfortune of timing put Mr. Wall in the position to face consecutive instead of concurrent sentences. We're merely asking that this court effectuate your colleague's desire below by reducing that sentence by just 6 months, which doesn't even get us to concurrent, but it gets us closer. Mr. Wall has already served his federal sentence, and so again, we're just asking this court to see that if the judge and the prosecution below both thought that any time beyond that sentence would be excessive, then by logic now, it is still excessive, and this very modest ask would bring us further in line with what we...
I'm sorry, if they thought it was excessive, why would the sentence have been entered as it was?
Because the lower court didn't have the ability to ensure that it would be concurrent. The federal sentencing happened after the state sentencing, and so the judge said several times on the record, we want this to be concurrent.
Is this consistent though with what the judge actually said? I mean, it's a nice argument, but is that really what the judge articulated? The judge said, I'm not guaranteeing, I don't know what's going to happen in the federal court. The judge didn't say, this is what I want, just said, if it works that way, that's great.
No, the judge did say that's what the judge wanted, Your Honor. The judge said, I'm recommending concurrent, even though I know I don't have control. So it's true. The judge, of course, acknowledged that he didn't have control over what would happen.
But he said, whatever happens, happens. That's what happens. That's what your agreement you're entering into.
And this court has the power to make it not so that whatever happens, happens, right? This court has the power to effectuate that desire of the judge below and the desire of the prosecution below. And if I can add, Your Honors, there have been developments in the time since even we filed this appellate brief that make this a more punitive experience than even the federal judge could have anticipated in entering this consecutive sentence. You know, I hope it's not inappropriate for me to mention that Mr. Wall is at Marcy, where a month after we filed our brief, 10 corrections officers murdered his peer around a group of nursing staff in cold blood. So the stakes of what we're talking about here as we split hairs over 6 months are pretty high. And so I just would like to emphasize to the court that we're talking about effectuating an existing deal that everybody agreed was the best case scenario. And now we're talking about that on top of a potentially fatal set of circumstances. So I would urge the court to consider that in reevaluating this sentence from below. If there are no further questions as to the sentence, I can turn to the suppression issue.
Go ahead.
Okay. So here, I think the main issue that that requires focus is that we're talking about a pocket bulge instead of a waistband bulge. And that's really what reasonable suspicion turns on in a case such as this, where we have a pocket bulge and no other indicia of criminal activity. We can't turn on equivocal circumstances to then say that police have reasonable suspicion. You know, the reason that the Court of Appeals and this court have made such a big distinction between waistband and pocket bulges is because there's unlikely to be any innocuous object that someone would ever hold in their waistband. It's just
Wasn't the police officer very clear about the way he described the bulge, that he knew from his experience that this wasn't an unidentifiable object, that this was a gun he was seeing? And he was pretty clear about that.
He was, Your Honor, and so were the officers in Solar and Williams, and those are two cases that indicate that even being clear on that doesn't get us over the level to reasonable suspicion.
How about People versus Wright, where the police officer was, his pants pocket weighted down by an, I mean, literally, this case is People versus Wright.
People versus Wright, Your Honor, predates the Court of Appeals distinction between waistband bulges and pocket bulges, so it's no longer a case that rules over this situation. Actually, every case that deals with a waistband bulge like Wright or Porcillo predates everything the Court of Appeals has said about the distinction between waistband and pocket bulges. So that is really not relevant to the consideration here. Of course, all of these cases turn on their individual facts, right? And the individual facts here are that we have officers watching Mr. Wall starting at 3 p.m. They notice an L-shaped bulge at 7:10 p.m. They don't do anything until 8:40 p.m. We have 90 minutes of observation with, yes, an L-shaped pocket bulge, which again is not enough by itself, and nothing else that happens in that time that gets us over to the edge to say that something was going to happen here, that there's a reason that there's any indicia of criminal activity. That's really relevant to this consideration. And I would add, Your Honors, if time permits, that we don't only have the baseline suppression issue, we also have a new element in the mix here, which is the structure of New York statute about this. We now live in a world where permits shall issue for concealed weapons. And so in that world, we have to reevaluate what's appropriate for police to consider in their assessment of whether there's reasonable suspicion. It's not just that under existing case law, an L-shaped pocket bulge isn't enough, which is already true. It's also now that we have to have reasonable suspicion that this was an unlicensed weapon. And that's a whole new element in the mix here. And so considering that every single federal circuit court to address this has held that the mere possession of a firearm in a shall issue jurisdiction is not enough to justify a Terry stop, there's really no basis purpose to deviate from that in this case. Thank you.
Sarah Lubin for the People. I'll begin by just briefly addressing the sentencing issue in this case. In this case, oh, I apologize. Thank you. In this case, Justice Mandelbaum, as was already pointed out, was very clear that he was able to make a recommendation of 4 years, but that the ultimate sentence, whether or not it was to run concurrent or consecutive, was ultimately going to be at the discretion of the federal judge presiding over Mr. Wall's supervision matter, or the matter that he owed time on based on violations of that federal supervision. And that's something that both defense counsel and Justice Mandelbaum acknowledged during sentencing. This was, just to clarify, this was a court offer that Mr. Wall accepted. This was not an offer from the people, and so there is some distinction there. But ultimately, the sentence should not be disturbed because the federal judge made a decision based on Mr. Wall's violations of his federal probation.
This is a plea to the indictment.
Yes, that's correct. There was only one count in this indictment. That this was appropriate based on the violations of supervision that had occurred repeatedly. I'll move on if there's no questions to the suppression issue in this case then. Officers certainly had at least level 2, if not level 3, when they approached.
So this wasn't, the officer didn't testify, I saw a bulge, right? He testified, I saw basically an L-shaped object that looked exactly like a gun in his pocket.
That's
It wasn't
correct.
like, I saw a big, something that looked like, could have been a cell phone, could have been a this, could have been a that.
That's
Instead, I saw an L-shaped object that looked exactly like a gun. I've seen this before. I know what it looks like, and that's what I saw.
That's correct, and this is exactly a case in which I would argue is much more, provides much more suspicion in a case like this if an officer is actually able to see the outline of a firearm. And
if I may, I want to add to that, right? Now, this area, multiple shootings in the area, and it just wasn't the L-shaped. It was also that, moving whatever was in the pocket and grabbing the pocket a number of times.
There was manipulation of the pocket. I don't know if the court has had the opportunity to see the video that was entered into evidence during the hearing. However, you do see repeatedly exactly that. You see the L-shaped bulge in defendant's pocket, and you also see him manipulating it, at least to my eyes, at least 3 times. I'd be happy to provide that video if the court hasn't had an opportunity, but that is exactly the distinction here, that this is actually much more than just a bulge at somebody's waist or a bulge in somebody's pocket. This goes beyond that because this is actually the outline of a firearm in a high crime area. Just briefly to turn to Bruin should not factor into a probable cause determination in this case. As the court is well aware, Bruin deals with the constitutionality of New York's licensing statute. However, officers are not in a position to determine whether or not an individual during these street level encounters has a permit in the moment, and it's unrealistic to believe that officers should be able to factor that into a probable cause determination. Officers need to be able to react in the moment to these changing situations. In addition, the exemption for licensing that's included in 26520 is just that, an exemption or a defense. It's something that a defendant would be able to affirmatively plead after being charged. In that sense, it doesn't make sense to ask officers to consider a negative while making these determinations. It's something that a defendant would ultimately have the opportunity, similar perhaps to a justification defense, something that would factor in later that a defendant would be able to argue later as an actual defense affirmatively. If there's no further questions, we rest on our brief.
Thank you.
Thank you.
So again, on the sentencing issue, I want to be clear, yes, it was a recommendation from the court, but I guess what I don't see an argument for is why not to get the sentence now as close to that recommendation as possible to effectuate the lower court's desire, because that is a power that is part of this panel's capabilities. And I haven't yet heard an argument from the prosecution as to why this additional time is merited. But turning away from...
So let me ask you a different question. Why is it excessive, right? You're
Well, the
arguing
judge
the sentence is excessive, but the sentencing judge clearly understood that this could be the sentence and didn't have any problem with that. So why is this 6 months more excessive?
Well, the judge did have a problem with it, right? I mean, the judge didn't want that to happen.
No, the judge acknowledged that the judge had no ability to affect it.
Right.
So that's not the same as saying this sentence is excessive if it goes the way, if the federal judge says anything.
Well, as a matter of logic, Your Honor, if the sentence that Mr. Wall is serving is longer than what the judge thought was appropriate, then that amount of time is inherently excessive.
The federal judge was asked to make it consecutive and clearly concurrent and rejected that request.
Yes, Your Honor, and we're urging the court to take seriously the recommendation of your colleague in this assessment. And okay, thank you, Your Honor.
People versus Diomande.
May I begin? Yes. Thank you. Dennis Metten, pro bono counsel for Khalid Diomande. I'll begin my argument today with the summation misconduct argument, and then I'll turn to sentencing. So on summation misconduct, this is not your typical summation misconduct case where only a few offhanded remarks are at issue.
I'm curious
There were dozens
how,
of misstatements in the process.
I'm curious how,
Sorry.
how the defense counsel preserved that issue, given that he failed to object to the adequacy of the court's curative instructions.
So I think you're referring to the one that the prosecutor requested at the end after the mistrial motion. Is that what you're referring to, Your Honor? So there were 24 objections throughout the contemporaneous objections throughout the closing arguments. There was a mid-summation sidebar with the prosecutor where the prosecutor was put on notice that some of his comments were going across the line, especially comments concerning denigrating the defense and bolstering and vouching for some of the witnesses, in particular the complainants that had testified. Despite promising that he would not, that he would stop doing that, he continued to do that after that sidebar, which prompted the mistrial motion that came at the end. And in response to that mistrial motion, this prosecutor requested a curative instruction. He requested that the court instruct the jury to disregard his own statements. And the court refused to do that. The court didn't want to do that because the court said it didn't want to find itself in the position of commenting on the prosecutor's own summation arguments, which is something that a court has to do when it's faced with summation misconduct. So the fact that the defense counsel didn't join in, I don't think really affects the preservation of the fact that he did file a mistrial motion with respect to all this.
Was the mistrial motion specific as to the comments made by the prosecutor in summation?
Yes, they were. They had to do with specific comments concerning police officer pensions and adverse employment consequences as a result of if they were caught in any type of lie or anything like that on the stand.
And those objections were sustained, right?
They were not sustained. They were not sustained on those. They were general objections, but they were not sustained on.
Okay, and then there was no further requests, correct?
From defense counsel?
Yeah.
There was the mistrial motion that followed.
The mistrial, no, at the time, there weren't any further statements about that, correct?
Further statements from defense counsel?
Yeah.
Again, as soon as he could.
And then People versus Vega says if at that time you don't say anything further, you don't preserve that objection, right?
But there is also a Court of Appeals decision that says that if you do file a mistrial, or if you do move for a mistrial, that does preserve that issue.
And then when the court issues a decision on it and then you don't further object, then you've lost that preservation, right?
No, the court specifically did say that it took defense counsel's refusal to join in on the curative instruction as an exception to the court's ruling. That's what the trial court said in that one. So that did So that is still preserved. It is our
The
position. that it's still
mistrial motion.
preserved. The mistrial motion with
Not-
respect
the
to
mistrial motion was, that was preserved, but the previous objections, you don't get to lump them all in a mistrial motion without, at the time, making specific objections, right?
So out of the 24 objections, there were still some specific objections.
Okay, so let's focus on the ones that were actually specific enough.
Okay, but so
Which of those are you talking about?
so at the moment, because there were so many objections, I can't say specifically which ones were.
Okay, all right.
So, but I'd also like to turn to some of the comments that the prosecutor himself made. So specifically, I want to turn to some of the comments that he made about the complainants. So none of the complainants were able to identify Mr. Diomande at trial, but that didn't stop the prosecutor from improperly trying to fill that gap in the people's case. The prosecutor told the jury that at least one complainant could identify Mr. Diomande, but was too scared to do so in court because, the prosecutor claimed, the complainant believed Mr. Diomande knew where he lived. But this complainant never said he was too scared to make an identification, never said he believed Mr. Diomande knew where he lived, and there was no evidence showing that Mr. Diomande actually knew where this person resided.
Hadn't there been evidence introduced about what the victim's route was to go from his home to the subway? And didn't that show essentially where he lived?
That did not show where he lived. That was just a route along his subway. It wasn't his apartment. It wasn't his, there was no address given. And critically here, Mr. Diomande didn't testify, so there was no evidence that he actually knew that. And there also was no evidence, especially from that complainant. The complainant never said that he was too scared to identify anybody. And he never said that he believed that he believed that Mr. Diomande knew where he lived. There was no evidence of that at all in the record. Since seeing as I have a few minutes, I'd like to.
So that objection, for example, was sustained, right? The defense counsel objected, the court sustained, gave a curative instruction to the jury. It's your recollection of the facts is the only thing that matters. And then there was no further curative actions that requested, correct?
But the court did not tell the jury to disregard that
Right,
statement.
but again, the defense counsel didn't ask for that, didn't ask for anything. The court gave a curative instruction, and defense counsel didn't ask for any further curative, right?
He didn't follow up on that, no.
All right.
So if I can, very quickly, I'll just turn to the sentencing issue. So on sentencing, there was plain error which warrants remand. Respondent concedes that Mr. Diomande was sentenced based on Penal Law Section 70.252-B. I'll refer to it as 2-B just for ease.
How did defense counsel preserve an objection to the sentencing court citing to that section?
So that doesn't require an objection because that specific provision doesn't apply to Mr. Diomande. The statute only applies.
But how did you preserve any objection to the sentencing court erroneously referring to that section?
So because it is an illegal sentence, it doesn't need to be preserved, and that is People v. Medina. It doesn't need to be objected to at the time.
Thank you. You could
Sentence isn't
expand.
illegal.
I'm sorry, do you want to answer the
It's
question?
okay. It's okay.
Okay, you can follow up on that in rebuttal.
May it please the court, Assistant District Attorney David Crowley for the people. If I can just jump right into the last thing that my friend here said. With respect to a lawful sentence, it does require preservation. We cite a case in our brief, People v. Diaby, D-I-A-B.
Is there anything unlawful about this sentence? I know the court misapprehended its sentencing discretion, but is there anything inherently unlawful about the sentence that was imposed?
There is not. It is.
Misapprehension doesn't make the sentence illegal.
That is correct. And so in Diaby, this court said defendant did not preserve its claim that the court misapprehended whether it had discretion to impose concurrent sentences. Here, you can get to 13 years, which is his sentence, of two ways. You can give it on the Rob 1, which has a max of well over 13, or you can stack it consecutively because there were two incidents, right? Two different victims. Defendant left one completely.
Your argument is that if the sentence is legal, then it does have to be preserved if you're going to object to the court's misapprehending its discretion.
Yes, and I would go one step further, which is that this court clearly did not want to impose something less than 13 years because even mistaking that bail provision she still could have imposed a sentence of 8.5 years. She thought 13 years was appropriate because she said it would not be appropriate to sentence the defendant to the minimum under any circumstances. This is the sentence the court wanted. It just cited the wrong provision to get there. Clearly, it had the authority to impose consecutive sentences, and if the defense counsel thought otherwise, it should have been objected to below. As for summation, that is also something where preservation is, I think, fatal here. There are a lot of different claims. A lot of things are, a lot of things were objected to, but not all of them are the ones that are raised in the brief.
Counsel, isn't it unusual, though, for a prosecutor to ask the court twice to give the jury a limiting instruction against the prosecutor's own statements?
I can't speak to how common it is. I think that was just the prosecutor being prophylactic, being prudential here, just being cautious, because that particular comment about the pensions, right? This was all part of a responsive, record-based argument trying to explain how, to use the ones that are challenging, how ludicrous the defense counsel's claim was that Officer May had planted a bullet and had lied about recovering property from the victim. This wasn't, as we see in some of the other cases, where a prosecutor comes into court and simply says, you should believe police officers. What do they have to gain? Why would they lie? They have their jobs. This wasn't a contention that police officers are more credible than regular witnesses. This was, let's look at the evidence in this case. And the prosecutor specifically pointed out the fact that in order for the defense counsel to have been accurate in his argument, Officer May would have had to, in front of all these other officers, pick up the gun, remove a bullet, go back to the precinct, plant it on the defendant, and falsely claim this. And also somehow he would have had to have found the watch that belonged to the victim from sources unknown and return it to the victim. And all of this just didn't make any sense. And particularly, why would he, in front of all of his colleagues, in front of other civilians walking by, in front of a camera, take an action as reckless as removing the bullet from the gun when it would be so easily detected? And that was his argument, purely record-based. And he added to it the point that, he had this pension, and so all he's saying is, if counsel's concerned about the fact that I mentioned a pension, go ahead and strike that. And to Your Honor's point, counsel said, I don't want that relief. I'm not participating in any limiting instruction. I want my mistrial. And the court said, well, if defense counsel is not asking for the limiting instruction, I'm not going to give it, right? I think it's because within the larger context, it was clear that the prosecutor was not vouching or bolstering. He wasn't lending his own credibility or the DA's office credibility to any of the witnesses. I'll add the one comment that we are talking about with respect to the victim's fear and his inability to identify the defendant in court. That was also directly responsive to arguments made by defense counsel. Counsel had said the defendant had come into court and he's sitting right here and neither victim could identify him. We don't do this beyond a reasonable doubt for sweatshirts, meaning identify him based on the hoodie. You got to identify the person who's here. And in summation, the prosecutor pointed out that both victims had ID'd the witnesses into show-ups shortly after the crime. And there was all this testimony about how scared, the victim had testified that he was really scared during the robbery. The testimony came out on cross that this was a, quote, very terrifying experience for the victim. Evidence came out about the neighborhood the victim lived in, that he lived with his aunt. There was the map of the victim's neighborhood, and he's testifying that even to this day, he has to take a different route to work because he's so fearful about the experience. So certainly there was a basis for saying that the victim was fearful, and I think it was a fair inference to say that that might have contributed to his ability to make an in-court identification. If there are no other questions, I ask that the court affirm and we rest on our brief. Thank you.
Thank you. I'm just going to address sentencing real quick. 2-B applies if someone is convicted of a violent felony offense committed after arraignment while released on recognizance or bail, but committed prior to the imposition of sentence on a pending felony charge.
Counsel, we know we understand that that's not what happened here. But the question is, notwithstanding that, is this a legal sentence? And if it is a legal sentence, then the court was allowed to sentence.
So I think we have a differing understanding of what a legal sentence is. If a statute prescribes certain conduct and a person is sentenced based on conduct that they didn't commit, then it is an illegal sentence. then what we're asking for is for remand so that the sentencing court can apply the proper sentence based on the proper law that actually does apply to Mr. Diomande, which 2-B is not that law in this case.
So the sentence that's actually imposed is unquestionably a legal amount of time. What needed to have happened here was for the defense counsel to say, Judge, you're considering something which you shouldn't in imposing the sentence. Why don't you reconsider it?
Because it doesn't apply to him. That's why. And still, it's just
It goes to the preservation issue, whether you have to preserve that objection. And if it's a legal sentence, you do have to preserve that. And and this defendant's attorney didn't preserve it.
it's if it is a statute that does not apply to this defendant, it doesn't need to be objected to. This court can still reach it, or at least within the interest of justice.
Thank you very much,
you, Your Honor.
and thank you very much for your pro bono service.
Thank you very much. Thank you.
Greatly appreciated.
Thank you.
Caitlyn Insurance versus Colony Insurance. Go ahead.
Good afternoon, Your Honor. My name is James Quinn. I'm here on behalf of the appellant, Caitlyn, Sandy Clarkson, and McAlpine Contracting. I'm here today to ask the court to reverse the lower court's decision that denied additional insured coverage to Sandy Clarkson on the basis that there was a lack of privity between Sandy Clarkson and Colony's named insured Kingstone.
So in these kind of cases, obviously, we have to look very closely at the language that's in the policy. So I know that the language you're relying on is organization required by written contract with a named insured to be named as an additional insured under Kingston's policy. So why does that apply to Sandy Clarkson?
Why does it apply?
Does it? That's your argument, right? That
Yes, that's correct.
That
Well,
Sandy Clarkson would be covered under that language.
It clearly, the persons or organizations that are in the subcontract is the owner and the general contractor. And the McAlpine...
Kingspan's subcontract required to name Clarkson and McAlpine?
The subcontract...
As additional insured?
The subcontract does name both Sandy Clarkson and McAlpine. It names Sandy Clarkson as the owner, and it names McAlpine specifically because that's the contract with whom Kingstone has the relationship. And in the subcontract, there is both a requirement to procure insurance that has a additional insured requirement to it, and that triggers or that qualifies the additional insured opportunity in the
colony
policy. And the colony policy, all it says is all persons or organizations as required by written contract with the named insured. That written contract with the named insured is Kingstone.
So your argument, just so I'm clear, is that this particular language does not require any specific written contract between Sandy Clarkson and Kingston.
Correct.
All that's required under this language is that there's a written contract in existence with Kingston that requires Sandy Clarkson to be named as an additional insured, and that is satisfied.
Follow that logic. There's a number of entities in that subcontract. There's an architect, there's a couple of other people who, under my argument, would also qualify.
We don't have to decide that today, though.
Okay. So yes, we do. And the language that we've got here is distinctively different than that which the lower court relies upon. And all of those cases that the lower court cites to, it's significantly different. And what the lower court said, and I'll point you to the record at 14, What the court below says is, despite the plain meaning of these words, okay, that we've just discussed, this is what the judge says: the use of the word "with" implies that coverage is available to those with whom Kingstone had a contract. I don't know.
You're saying that's not what this agreement says, though?
The agreement does not say with whom. There's no with whom in the.
Let me ask you, with the limited time that you have left, do you want to address the issue about primary and contributory basis, how the insurance, assuming you win on the first argument, how, who should give the primary insurance?
Well, the primary insurance and and who goes first, there's a provision, there's an endorsement that's exactly identical to the additional insured endorsement. And so if you find on behalf of us having insured coverage under the additional insured endorsement, the other endorsement follows, because the language is exactly the same. So they rise or fall in the same agreement.
So you're saying if you win on the first issue, you have to win on the second issue?
Absolutely. Yeah, that's
Okay, thank you.
Good afternoon, Your Honors. Lester Channon from Farber, Bronx, and Zane.
Let me ask you the opposite question.
Pardon me?
Where in the language of this Kingstone policy does it say that there is an actual, that it's required for there to be an actual contract between Kingston and Sandy Clarkson for there to be additional insured coverage? Where is that language in this?
Well, it's our contention that the plain reading of this very short phrase does just that.
So I'm looking at the plain language, and it says an organization required by written contract with a named insured to be named as an additional insured under Kingston's policy. Why wouldn't Sandy Clarkson fit squarely into this, in that it is an organization required by written contract with Kingstone to be named as an additional insured? Why doesn't it fit squarely into the terms of this provision?
It seems that the use of the language "all persons or organizations," and then it proceeds from there, implies that all persons and organizations should have that contract with Kingstone.
Are you writing out the language about organization required by written contract with a named insured? That seems to be the dispositive language. I'm not sure what the basis is for arguing that Sandy Clarkson wouldn't be that organization.
Only to the extent that the reference to all persons and organizations as being the universe of potential additional insureds, it seems by implication that those persons or organizations ought to have the contract with the named insured, being Kingstone.
So you're saying it does, but it doesn't say that.
It implies that.
When you say it implies that,
Yeah.
that means it doesn't say that. It
Well,
says
I don't know, implication
there has to be a contract, right? There has to be a contract requiring someone to cover this party, but it doesn't say that it has to be between the two parties, right?
Well, I guess our position is that an implication is sufficient to impose that obligation. In addition to that, we just point out this is nothing that's in dispute here, but that however the court rules, that it is premature concerning the duty to defend. It's premature to decide the indemnification obligation as to McAlpin in particular, and if you reverse on Sandy Clarkson, then as concerns Sandy Clarkson as well, because there's been no determination in the underlying action as to whether or not it arose out of the acts and omissions of our.
Didn't we modified on, we modified the last, on that one, we modified, right, and said.
Well, there was a reversal on McAlpin.
Right.
So initially, the lower court had found that
Right.
McAlpin it didn't arise out of McAlpin's acts and
So
omissions.
that would be the same thing here.
Yeah, so we're just.
So it'd be
that's-
premature there, it's premature here.
Yes.
But not on the duty to defend, right?
Well, our position is Yes, duty to defend McAlpin, we're not disputing that. No, our position is, based on the implications of the provision, that Sandy Clarkson's not an additional insured, therefore no duty to defend or
But
indemnify.
otherwise, you concede the duty.
Or
Thank you.
reimburse.
Thank you.
To your last point, Judge, in the record at 229 is the endorsement for additional insured coverage. In the record at 257 is the primary non-contributory endorsement, and you'll notice that the description of the people insured is the same language. It's all persons or organizations as required by written contract with the named insured. So they rise and fall together, I think. And one last thing I just point out, the language that the court below implies, and then the case authority upon which it then relies, is substantially different from from the colony language. It's just, it goes on. Any person or this is Liberty's language in Gilbane. Any person or organization with whom you have agreed to add as an additional insured by written contract. In the Dynatech case, the Burlington policy says, and any person or organization with whom you agreed because of a written contract, written agreement, or permit to provide insurance. And finally, in the ACC case, again.
We'll look at the case.
Okay.
Thank you very much.
Thank you very much.
558 7th Avenue versus E&B Barbers. It's just you.
Yes, me.
Not just you, but just you, mean there's no other party here.
Yes, I understood.
No other implication.
Yes. It's not the first time, will probably not be the last. If it please the court, Paul Gruber from Borough Goldstein for the appellant. We believe the court below erred in two respects. One, with respect to the dismissal of the claim against the guarantor, and secondly, in not granting summary
As
judgment.
to the guarantor, your argument is that the court below should make a finding on the constitutionality.
Absolutely.
So you want it to be remanded for the court to make a determination
and
on that.
since the statute seems to require that the city be joined, they should be afforded that option as well.
Okay, so what about then the tenant and why you should get summary
The
judgment?
tenant, well, they interposed an answer that contained 25 defenses, which remarkably, all of which were stricken. They attempted to move to amend their answer to assert a defense of constructive eviction. That motion was denied by Judge Rosado. There's no appeal from it. And there's no circumstance here which supports either the constructive eviction or the other theories.
One of your arguments is clearly that they never amended, so they don't have a construction eviction claim because it was never granted. What other arguments do you have as to why the construction eviction claim fails?
Well, essentially, what's the wrongful act of the owner here? The premises are a little unique in that it's a lower level premises in the building off of Times Square, and the access is through a subway corridor. The lease says that the only obligation the landlord had with respect to the tenant, with respect to that corridor, was to maintain it, and the common meaning of that would be to keep it clean and to replace the lighting.
Doesn't this argument run into a problem in terms of it? If that's the argument you want to rely on, doesn't that run into the problem of raising some kind of factual issue?
Well, that
as to
doesn't
what
change
the condition-
liability.
Do you have any legal arguments that are not factual-based arguments?
But the judge basically looked at paragraph 23 of the lease, which is the quiet enjoyment paragraph. And to put it simply, the judge interpreted those two words in the Webster's sense rather than the Black's Law Dictionary sense. Quiet enjoyment has a precise legal definition, as the court's aware. The tenant never vacated. In fact, the only anything.
That's exactly right. That is undisputed.
Yes.
That the tenant didn't vacate.
The tenant did not
And
vacate.
the tenant was in default at the time.
At the time.
So whatever the obligation may or may not be, doesn't that dispositively say you cannot assert that claim?
That's correct.
Okay.
And is that an argument you're making?
What?
Is that an argument you're making?
It's in the brief.
Okay. I just want to make sure you're making that argument, because that's not what you led with.
Yes.
Okay.
So, the tenant did in March 2020, did close based on the executive.
The tenant did close, and the parties...
Based on the executive order.
Yes, if I could
Then
finish.
came back in.
Right, the tenant did come back in, and the...
Then leaves in January without paying
Right, the
rent.
parties did negotiate an agreement that would have given him some conditional considerations had he not defaulted under the lease to accommodate for the fact that the world was a little chaotic back then.
Thank you.
Unless there are further questions. Thank you very much.
Thank you very much. West 18th Street versus Allen.
Good afternoon, Your Honors. May it please the Court. My name is Marion Harris of Pryor Cashman, LLP, on behalf of Defendant Appellate Marcy Allen. This appeal arises out of the Supreme Court's opinion and order granting a commercial landlord's pre-discovery summary judgment motion against Marcy Allen, the guarantor. In opposition to landlord's motion for summary judgment, which I'll note was facially defective for failure to comply with Uniform Rule 202.8-G, and therefore should have been dismissed on that basis alone, appellant submitted an affidavit attesting to the actual...
Counsel, how are you going to distinguish 373, 381 versus IDECO, which has very similar facts to this case? That was also a case where the tenant claimed it was having large live-scale events, but the live events were prohibited by the lease, which stated as here that tenant's premises would be used as an office and no other purpose. And in that case, the court did not accept the argument your client's trying to make. Why is this case any different than that case?
I think that, and much like the court below, looking only at the conclusion, the similarity may be striking, but the first department, when it analyzed the case, looked at the actual uses of the premises. I'm not saying that what's recited in the lease isn't informative, but the actual evidence marshaled or failed to be marshaled by the tenant is also
But here we only have a bare bones affidavit from the tenant about the other uses of space. There's absolutely no other evidence other than a bare bones allegation to support the claim, and the use that she is describing is prohibited by the terms of the lease, just like in IDECO.
But, Your Honor, I would submit that there's nothing in Section 22-1005 that restricts the application of the prohibition of the enforcement of the guarantee to the use restriction recited in the lease. There's nothing in the adopting language or any of the surrounding consideration by the New York City Council that says we intend to provide an administrative enforcement for private contract. No, it addresses the actual use, which is what the governor's executive orders addressed.
Then how do you deal with your bare bones allegation about the actual use?
My client has provided the personal knowledge that she has, which is that she used the premises in connection with the business, which is a experiential agency that brings together brands and musical talent, that there were bi-weekly performances.
Provided no documentary evidence of that or anything?
And I will point you, prior to the commencement of the action, my client's email was changed in a way that those messages are no longer available. It's recited in the affidavit. I believe it's record page 145, note 1. My client doesn't have personal crystal memory as to the number of attendees at these events, but believes that they qualified under Executive Order 202.3.
But that doesn't get you out of the fact that you're not allowed to do that under your lease.
Respectfully, this is an action with respect to enforcement of the guarantee. If there's
Right.
an issue with
And if
respect
there's a breach of the lease, which by having these performances, your client's clearly breaching the lease, then the guarantee, then whatever is due under the lease is due under the guarantee, right?
I guess I want to be clear. My client is the guarantor.
I'm sorry, that's right.
I do not
Right,
represent
right,
the
right.
tenant. The
Oh,
tenant
right.
was approached in a
Exactly,
separate
right.
action.
So you are liable for anything that the tenant owed. If the tenant breaches the lease, that's the whole point of the guarantee.
Provided the guarantee is enforceable under the law. And
So why would this guarantee not be enforceable?
there's nothing in the language of Section 22-1005 that provides the requirement that you're articulating now, which is that the use must be consistent with the recited use in the lease. It's an assumption that's underlying
I don't understand what even that means. If there's a breach of the lease, the guarantee requires the guarantor to either pay the money that's due or cure.
You're relying on the guarantee law, though. That's what you're relying on.
And to be clear here, there was no allegation of a non-conforming use. There was I believe it was a default with respect to the
You're saying that under
tenant.
the guarantee law, you're not required.
Correct.
You've
Under
shown
22-1005, the question is the guarantee enforceable against my client, a natural person for which the tenant's business was adversely affected by the executive order?
But the tenant would have to have an excuse to get out of the lease for that to help you. And what the use that you want to point to under the lease, that these performances, the lease didn't permit those performances. So therefore, it wouldn't have been closed down by COVID.
I guess we're talking in circles. At bottom, the question is, what does the statute that was enacted?
So I guess right. So what you're saying is, sure, we were doing something illegal and not permitted under the lease, illegal, but we're nevertheless, because we were doing it, just because we were doing it, that vitiates the guarantee. That's tough.
And
that's a tough position.
To be clear, I'm not saying that. There have been no findings with respect to the use.
Exactly what you're saying.
If I can just refer the court, the recitation in the lease is executive, administrative, and general offices of a marketing/music sponsorship company. Standing here today, there's been no findings, no argument, no conclusions with respect to whether the lease is conforming or not
I'm going to let you
conforming.
expand on that in rebuttal. Thank you.
Very much. Thank you.
May it please the court. My name is Todd Lawler, law firm Sternbach Lawler Alderella, on behalf of the respondent. At issue before this court is whether the lower court's granting of summary judgment and its reliance on the Adecco case was proper. The answer is unequivocally yes. In fact, as this court just pointed out, the Adecco case facts parallel this instant matter almost to the point of the fact that
Because the tenant could keep the business open and do all the stuff that is allowed under the terms of the lease.
I'm sorry?
Even if the live events were prohibited, that wasn't the main purpose of what the lease was for. The lease was to be used as an office space, so the tenant could continue to stay open and use the space.
Correct.
I'm making your argument.
No, correct. Article 2 of the lease, like it was in Adecco, the use provision is an important provision. It was negotiated by two commercial tenants, and it specifically and unequivocally concerns the use only for the purposes of offices. There's no dispute as to that, and any use of the premises for a live performances over the course of years is contrary to the lease, and it's a breach of the lease. It would be a perverse result if a guarantor can use a breach of the lease to dovetail into the New York City guarantee law to evade personal liability.
And that's what the
under a
court
lease
held
that
in
it promised
Adecco.
to.
And that's what the court held in Adecco.
That's right.
Okay,
And on
thanks.
its face, the permitted use under the lease would not have closed the premises.
No, the premises were never closed. The premises were never closed, and the guarantee law specifically says that, like going a step further and looking at the averment of Miss Allen, which is vague and is not specific as to what was going on, what was planned going on, anything. There's very little specificity about any of the events that were purportedly going on in the space. Importantly, there's no averment that anything was canceled, nor that.
No, it's
Yeah.
a very bare bones affidavit.
That's right.
Thank you, counsel.
Thank you.
To start off, I guess I want to pick up where I left off, which is what the lease says. The use restriction in the lease provides that the premises were to be used for executive, administrative, and general offices of a marketing and music sponsorship company.
Right, which says nothing about public performance, right?
I can't say that. What does a music sponsorship company do? We can sit here, I'm sure you're all familiar.
It says executive administrative offices.
And general offices. What are the general offices of a music sponsorship company?
I mean, if you're arguing to us that would include cabaret performances, again, that's a tough argument to make. It's pretty clear. It's not unclear language. In fact, it's almost always that kind of language that is used in a lease to describe administrative offices. So there's nothing in that that would lead me, I don't think, a reasonable person to say, oh yes, you could have a cabaret performance under that.
Ultimately, it wasn't litigated below. This was never pursued against the tenant. I'm here on behalf of the guarantor in an action against the guarantor. I would like to point your honors to 389.
But
It
you
only comes up.
Go ahead.
It only comes up in terms of a guarantee because you're relying on the guarantee law, which is not even a defense available to the tenant. So there's no way this issue would even come up except as to the guarantee.
But to your honor's prior questions, if a non-conforming use was a breach of the lease, it would have been pursued against the tenant in the
Right, but this is not the issue in this case. The issue in this case is specific to the guarantor because it's only about whether the guarantee law is applicable or not. So
Understood. I would like to point your attention to a New York Supreme case that I think is instructive here.
Trial level case?
Yeah, it is a trial level case. 389 Associates versus Isabella Jules. There, the use restriction in the lease was for use as offices and showrooms for sale, wholesale only of ladies' accessories. The affidavit evidence put on showed that it in fact functioned as a retail establishment, a non-conforming use, and the court ultimately granted guarantor's motion to be dismissed.
And are you suggesting we're bound by that?
I'm suggesting that the actual use, that the evidence put on is instructive in construing the application.
Thank you very much. People versus Shamar Ross.
Good afternoon, Christiana Preda-Lee, Office of Appellate Defender, on behalf of Shamar Ross. Mr. Ross was deprived of his right to a fair trial due to the introduction of irrelevant, extremely prejudicial Molyneux evidence that consumed the charges before the jury. Here, despite the shooting of Carter occurring with the presence of multiple eyewitnesses, witnesses who Carter identified by name to the police, Carter was the only witness who identified Mr. Ross as the shooter, and his testimony was the only thing linking Mr. Ross to the shooting that was before the jury. And given that his testimony was shaky and inconsistent, the prosecution has sought to omit through its Molyneux application a speculative backstory to give a motive.
Speak up a little. I'm having a little trouble.
Yes, Your Honor.
I'll bring the microphone closer.
So the prosecution sought to omit here a speculative backstory to give a motive for this otherwise inexplicable shooting that.
I just want to go back. How was it shaky? What parts were shaky? Because I think it was
Yes.
pretty consistent. You know, gave the nickname, how long they've known each other, where he lived, where the grandmother lived, where the girlfriend lived. So what part of it was shaky that he shot him?
Yes, so the identification itself was not shaky, besides the fact that he misdescribed what the shooter was wearing. But we are saying that the testimony
He did say he shot him.
He did say he shot him, and that was clear. But his testimony, he did blatantly lie to the court as to the pending charges he had before the court, before another court. So his testimony, there was reason to doubt it as to this, that he was thoroughly impeached on his testimony multiple times. And given that his testimony, he was not the most reliable of witnesses and that the prosecution did not have other bases to link Mr. Ross to the shooting, it sought to omit this backstory through its Molyneux evidence. And this backstory was that a shooting years prior, which neither involved Carter or Mr. Ross, was the motive for the shooting.
Why wouldn't that, I mean, one of the reasons you're allowed to allow in Molyneux evidence is to provide a motive. Why wouldn't that evidence be relevant to providing a motive for why defendant was attempting to kill the victim? I mean, it seems clearly that it could be relevant. Whether or not he's credible or not, it seems relevant. So that's exactly the Molyneux analysis you're supposed to engage in. What's wrong with that?
So motive,
At least as to him, Carter.
yes, Your Honor. Motive is a basis for Molyneux evidence, but it also has to be relevant, and relevance requires both a temporal connection and a logical connection, as the Court of Appeals recently stated.
Why isn't
and
it relevant? That's what I don't understand.
Yes.
It seems very relevant to me. If I was on a jury, I would think that's
So, Your
relevant
Honor,
evidence.
here it was just too remote and too speculative. The
Right,
cases
but that was the
require.
very first time he hadn't been at the building. He witnessed it. He hadn't been back at the building since, and this was his very first time at the back of the building, and he was shot. So that does create some argument that it is relevant to the motivation based on that very unique timing.
Yes, and we're saying that it's just too old to establish relevance here.
Right,
The cases
but how do we
require.
weigh in the fact that that was his very first time back at the building after he witnessed that homicide and this person shot him, or allegedly shot him?
Yes, and his testimony is also inconsistent as to whether or not this is his first time
Sorry,
back.
if
He
you
has
could
a,
speak up.
yes, Your Honor. His testimony is, we have reason to doubt his testimony that this is his first time back, but regardless of that, this backstory is just simply too speculative here, that it occurred so long ago. And yes, that the respondent says that the animosity continued through this period. This is just simply too old here to have it continue over 3 years. The cases require.
Issue about the Molyneux argument. The Molyneux rule applies to evidence of a defendant's uncharged crimes or prior misconduct, but the evidence that was introduced doesn't show that defendant had alleged any connection between defendant and Mr. Kilpatrick's murder. So why is that even? Why does the Molyneux rule come into effect?
And there are cases that say that Molyneux applies where someone who's not implicated in a shooting but is implicated by guilt by association is also covered. So we would point this court to People v. Hemingway, which is from this court, as well as People v. Davis. These cases say that where someone is implicated by guilt by association, it is irrelevant, it is covered in Molyneux and irrelevant.
Well,
And here.
There are two parts to the Molyneux ruling, is there not? One was allowing in the evidence about the defendant being involved in the drug trade, which it's hard to understand what the justification for allowing that in. But then allowing in the evidence about the 2003 Kilpatrick killing and the fact that Carter was present and that there was an altercation, to put in that backdrop, what's wrong with that?
As we're saying, Your Honor, it is just simply too speculative. But even if this court were to find that it was weakly relevant, it is also extremely prejudicial. The prosecution was allowed to question Mr. Carter at length about this. They got in 10 pages of testimony before they were even allowed to charge question.
As Judge Kern said, you know, it relates back to the last time he was at the building, which is when that killing took place. And now he comes back and the charges, and Carter testifies that the defendant shot him 6 times. So it seems to be relevant, and I don't know why that's so prejudicial. It seems to me it's a fair attempt by the people to provide a motive and theory to the case. Unlike, you know, when you talk about the drugs, I see your point, certainly, that has a Molyneux problem.
Yes, Your Honor. Well, if I may, this case was a one-witness identification case that his testimony was the only thing tying Mr. Ross
Really
to the
one
shooter.
witness. It's like the person who was shot, right?
Yes.
That's a little.
Yes.
it's
Which
the
we have reason to doubt his
victim,
testimony,
right?
but even if.
So again, what is prejudicial about saying I was at the building when his friend was shot? What's prejudicial to the defendant?
Because it implicates him in this shooting, it implicates him by guilt by association.
There was nothing to implicate that the defendant was the shooter, right?
No, but it implicates him as a gang member and a friend of the shooter, of the victim of the shooting.
Was there anything about gang member with the friend shooting the years before?
Yes, there was, Your Honor.
So you're saying it was prejudicial because he said he was a friend of a gang member?
A friend of a gang member who was seeking revenge, and thus by guilt by association, he was implicated here.
Thank you.
Thank you. And if I may.
You have time for rebuttal. Thank you.
Good afternoon, Your Honors. Jamie Matson for the People.
So it is a one-witness case, but just some important corroborative elements, are there not? The fact that, but didn't the defendant assume a different name when approached by the police at the time of arrest? Doesn't he take off right after the crime? There are some indications here which support the testimony that Carter presents.
I think that's absolutely correct. Carter identified the shooter, defendant Shamar Ross, by name, by nickname, by face, by physical description, and by clothing description. He had every reason to be able to make that identification based on his strong familiarity with the defendant's friends, the defendant's family members, and the defendant's girlfriend, all of whom he listed almost by name and by apartment number within 1990 Lexington Avenue. He had the opportunity to see Shamar Ross's face as Shamar Ross peered into his car, and within a distance of less than 3 feet, he stared at Carter straight in his face. So there is a very strong identification here. It was corroborated by the video stills, which showed that the shooter matched the physical description and clothing description that Carter gave. It placed defendant at the scene, at the crime, and the finer details of Carter's testimony also gave the jury every reason to believe that his identification was credible, and every reason to believe that when Carter said he was certain.
Let me turn your attention to the Molyneux issue. What justified allowing in the evidence about the drug dealing?
Sure. So I think there were two aspects of this Molyneux application, the first of which is the 2003 homicide, which is not actually Molyneux. But turning to your question, the drug dealing is the only part of that theory that had to pass through the Molyneux two-part inquiry. The relevance of the drug dealing is that defendant sold drugs with the victim of the 2003 homicide. And Carter testified that defendant was close friends with that victim, that they were together, quote, all the time. And that shows the strength of the affinity of the relationship. Because if you think about it—
This had nothing to do with a bad drug sale or anything like that, right?
No, exactly, and that's actually why—
Then why is that relevant? Molyneux evidence. Why did not testify just that he knew who he was and he knew who he had been? Why is the drug dealing relevant?
I see. I'm sorry for interrupting at all.
No, yeah.
So I think that the fact that they were selling drugs together, aside from close friends, it goes to show the lengths that the defendant would have gone to avenge his friend's death. Because after all, we're more likely to act on behalf of somebody who we are close friends with or whom we work with. It just so happens that their business that the defendant and his friend were in was being in a gang. But this is why the judge's decision here and its ruling was so prudent, because the judge knew to strip away any reference of gang activity, because that would have been the most prejudicial aspect of this Molyneux theory. And he reduced it to just mentioning drug interactions and selling drugs together.
Why not just reduce it to the fact that they were friends, that they knew each other, that they knew where they lived, they had been in the building? That would have avoided any prejudice, right?
Any prejudice, perhaps, but the very minimal prejudice of the jury hearing that they sold drugs together in no way, I think, swayed their verdict such that it was an unfair verdict in this case. And I think the drug dealing still is important, because it's not that they're just friends. They work together. They sold drugs together. And I think what I want to correct, too, is that the prosecutor adhered to this ruling. At no point did they ever mention that the defendant was part of the gang. They never hinted that the defendant was part of the gang. Those are solely the words and inferences of the defense counsel, not the words of the prosecutor here.
Thank you very much.
Thank you very much.
Your Honors, I'd like to just say that the reason that this is so prejudicial is because the charges before the court had nothing to do with drug dealing. And it was only this motive evidence that gave that back.
Let's separate the drug dealing from the other testimony. Why, even if that was an error in the court's part, why wasn't that not enough or insufficient, because there was so much other evidence to incriminate him other than that testimony about the drug dealing?
And there wasn't other evidence to incriminate him beyond Carter's testimony, which we had reason to doubt. There was no forensic evidence.
Putting aside the Carter issue and just separating out the issue about the drugs, there was overwhelming evidence of his guilt based on Carter's testimony. So, and why wasn't any evidence about the drug dealing harmless error?
Your
Even
Honor,
if it was error.
we would say that it's not harmless error because where we have no other linkage besides Carter's testimony. That getting all of
Well, he
this
saw the
in
murder, that's the
is-
other linkage, and that he saw it was him.
Yes, Your Honor. And if I may just address our excessive sentence point very
No,
briefly.
no, your time's up. You can't bring up a new point now. Thank you. Jones, People versus Hines.
Good afternoon. Sam Claflin of the Legal Aid Society for Arthur Hines. The physical evidence should have been suppressed. The police lacked probable cause to arrest Mr. Hines. At the time of his arrest, the evidence was, at most, that he was smoking a cigarette in a distinctive way outside and the smell of marijuana in the area. This court's decision in Grunwald controls. There, the defendant smoking a cigarette in a distinctive way and the smell of PCP, plus him not responding when police called to him, the cigarette being visually distinctive, and police seeing him discard it when they approached, did not even amount to reasonable suspicion, let alone probable cause. That decision controls here. The prosecution relies on Andrews, a distinguishable second department case. There, the factors supporting probable cause again included the distinctive way the cigarette was rolled and police seeing the defendant discard it when they approached. Neither factor is present in this case. Further, in Andrews, the defendant's breath smelled of marijuana when the officers spoke to him. So there's no contest here. Grunwald is the controlling case. The arrest was not supported by probable cause.
I just want to go back if I can.
Please.
There's a waiver of appeal. So if the waiver was valid, you know, we don't even address this, right?
If the waiver was valid, Your Honor, that's right. But here the waiver was not valid.
Why?
The court said the waiver was an absolute bar to an appeal, and the court's colloquy never mentioned non-waivable appellate claims. Under this court's recent decisions in Trulove, Rochester, and Cruz, that alone is enough to invalidate the waiver here. But further, the court told Mr. Hines he was waiving his rights to appellate counsel and to be assigned appellate counsel. He could not waive either right under the Court of Appeals decision in Shanks. And so additionally, that invalidated the waiver here. The form had very similar defects. This waiver was no good. On top of the probable cause issue, the evidence should have been suppressed even for another basis. There was an independent problem with the inventory search in this case. The policy on which the prosecution relied at the hearing was standardless for non-automobile property. And further, it had no rules for closed containers as to non-automobile property. On top of that, the vouchering here that actually happened was arbitrary. So starting with the policy said that for non-automobile property, property may be inventoried and it may be invoiced. So that violates the Court of Appeals rule in Galak.
Was the inventory search argument preserved?
Yes, it was, Judge.
How?
So first, the hearing court explicitly decided that this was a valid inventory search. That's all that CPL 470.05 requires in terms of preservation. Also, the prosecution put this issue before the court. It admitted this policy and evidence, said it was a sufficient basis to justify the search. Prosecution elicited testimony as to that. Further, defense counsel.
Did you raise the issue which you raised on appeal about the constitutionality of the patrol guide?
So counsel did challenge it as an inventory search in a general sense.
Was there any challenge to the constitutionality?
That precise challenge was not made below.
That's not preserved. We agree, correct?
I disagree respectfully because I believe the fact that this was found to be a valid inventory search is sufficient to preserve this general challenge. The Court of Appeals said in DeBoer that in a suppression context, when the defense challenges the validity of the search, mere emphasis of one prong of attack over another or a shift in theory on appeal will not constitute a failure to preserve. And again, the court below explicitly found that this was a valid inventory search. And so the issue was litigated.
The issue about the patrol guide, did the court below find that the patrol guide was constitutional?
necessarily in order to validate the inventory search on that basis, Your Honor.
So you'd have to raise, you're saying that in any case, regardless of the constitutionality being raised in any possible way, so you don't have to raise that once an inventory search is found to be valid?
I believe under this state's preservation law, yes, that's
Okay,
true, Judge.
fair
But
enough.
regardless, this court does not have to reach the inventory search issue. Again, the initial problem with the lack of probable cause is sufficient to suppress all of the evidence in this case and dismiss the indictment. If I may, I'll shift to the diversion issue briefly.
You only have 7 seconds, so why don't you do that on rebuttal?
Very well. Thank you, Judge.
Good afternoon. May it please the court, Caroline Williamson for the people. As a threshold issue, the waiver of appeal was completely valid and forecloses review of each of these issues. Justice Farber properly distinguished between trial rights and appellate rights. He clarified that the right to appeal is separate and distinct, and that ordinarily a defendant retains the right to appeal a conviction even after pleading guilty. He certainly did not say that the waiver was an absolute bar to appeal, and he did not tell defendant that he was waiving his right to appellate counsel.
I want to ask you one question. Have we ever said that the fact that you don't list every single appellate right that remains after a waiver is enough to invalidate an appeal?
No, never. And in fact, Thomas stands for the proposition that the court does not need to explain the full legal details of preserved appellate rights when explaining a waiver. So it is not of any importance that he did not walk defendant through illegal sentence claims, which were in fact addressed in the written waiver, which this court has upheld several waivers of appeal based on this exact written waiver, so it was not deficient. With respect to—
Counsel, I just want to go back and here the court did confirm with the defendant that he reviewed the waiver with counsel and he understood it.
Yes, in fact, he specifically asked defendant if he had read the waiver, and defendant said somewhat. Court said, no, you must read it entirely. I want you to confirm that you read it entirely and still want to waive your right to appeal. He did so, and it was confirmed on the record that he consulted with counsel before he confirmed again that he wanted to waive his right to appeal. So there's no issue with respect to the waiver of appeal. But with respect to the probable cause, I just want to mention that in Grunwald, which defendant relies on, in fact, when the finding was made about the validity of the stop, no PCP smell had been identified yet. The stop was made entirely on the basis of the visual observation of a particular kind of cigarette, and it was only after that stop that the smell came into play. So in that case, unlike in this case, there was only a visual observation, whereas here, there was the visual observation, there was the strong odor of marijuana, which continued as they followed defendant down a street that all of the testimony indicates was devoid of any other people.
And he threw the cigarette down, right?
He did throw the cigarette down. For purposes of this search, to be on the conservative side, we did not factor that into our probable cause analysis because the court below held that the arrest was in place at the time that they stopped him before they had collected the cigarette, and we're not arguing with the decision that the court made about when the stop was turned into an arrest. But we think that alone, the odor, the fact that there was no one else around and they saw him smoking in this distinctive fashion, following him down the block, and we're only 15 feet away, that is much more like Andrews and Smith than it is like Grunwald, where again, the stop was only on the basis of observation. When it comes to the vouchers, we would just like to say that this issue was not preserved, the specific argument about the vouchers not being proper, and it's easy to see why, because the vouchers were in defense counsel's possession at the time of the suppression hearing, so that's why they didn't make the argument that the vouchers weren't proper, and that's why the people pointed out in response to this brand new argument that the vouchers were in fact completely valid and complete.
Thank you.
Thank you.
On the probable cause issue, it is not true that the police saw Mr. Hines discard the cigarette. The testimony is actually that when they approached, there was no longer a cigarette there. So they did not see him ditch it, as the police did see in
They
it.
said they're not relying on that, though, right? They're not relying on the ditching of the cigarette to support.
That's right. I was correcting the record as to what the prosecution just represented. Further, the testimony was not that there was no one else around. I concede that it was not crowded at the time, but it's not at all true that there was no one else around. And the prosecution's effort to distinguish Grunwald is entirely unpersuasive. Grunwald explicitly explains when probable cause existed in that case and when it did not exist. That's all in the decision. And this court said in Grunwald, probable cause did not exist until the defendant pulled the knife. And so necessarily anything up to that point was not sufficient indicia for there to be probable cause. And necessarily that controls here. In Smith, which the prosecution also relies on, part of the evidence was the police finding the, quote, blunt after defendant dropped it, and then they confirmed the smell like at that time, and that was sufficient. Thanks so much.